Good afternoon. I'm Attorney Karen Jimeno.
And I'm Attorney Edwin Lacierda.
You're watching BNC's VP Sara on Trial, a BNC impeachment coverage.
We'll bring you the Senate Impeachment Court's proceedings live here on BNC and our social media pages.
We'll get updates from our reporters deployed at the Senate today. Hannah T., Dexter Ganibe, Isaiah Mirafuentes, and Jill Sebandal. Let's check the situation outside the Senate premises. Jill Sebandal is there. Go ahead, Jill.
Karen, mas mahigpit na ipinapatupad ngayon ang seguridad dito sa labas ng Senado. Dahil nga yan sa pagsisimula ng 92 days of impeachment trial ni Vice President Sara Duterte. Sa kasalukuyan nasa ating likuran ang mga pro-impeachment at nandun naman sa bandang harapan natin yung mga no to impeachment for VP Sara. Sa ngayon, nag-deploy ang mga otoridad ng karagdagang pulis sa paligid ng Senado or ng Senate complex habang naglagay rin ng mga barbed wire barricades dahil nga yan sa pinapatupad na seguridad along Cignal Boulevard bilang bahagi ng mas pinaigting na hakbang sa seguridad. Layunin nito na mas higpitan ang akses sa lugar at mapanatili ang kasalukuyan habang isinasagawa ang paglilitis. Habang pinapayuhan din ang mga ibang motorista at mga commuters na mga dumadaan dito sa Cignal Boulevard, pinapayuhan sila, Karen, na wag muna or i-avoid muna itong ruta na ito dahil nga inaasahan ng mga otoridad na mas maraming grupo ang darating dito sa harapan ng Senado para kanya-kanyang isigaw ang kanilang mga paninindigan. Magkasamang nagbabantay ngayon ang mga tauhan ng Philippine National Police at ng USAA. Kabilang na rin ang mga ginagawa ng USAA ngayon na inspeksyon sa seguridad ng mga nandirito. Nananatiling naka-full alert ang mga otoridad habang dumarating ang mga senador at mga abogado at kawani ng korte at miyembro ng media at iba pang otoridad at mga otorisadong individual. Ayon sa otoridad, mananatiling ipapatupad ang mas mahigpit na seguridad sa buong panahon ng paglilitis upang matiyak ang kaayusan. Karen?
Thank you so much, Jill Sebandal. Now let's go inside the Senate where the trial has just started. Let's go and see the live pictures of the Senate.
Totohanang mapatutunayan sa paglilitis. Ipagkakaloob ng saligang batas sa Senado ang natatanging kapangyarihang dinggin, litisin at pagpasyan ang lahat ng kaso ng impeachment. Kakibat ito ang pananugutang tiyakin na ang paglilitis ay isinasagawa ng may integridad, kaayusan at buong paggalang sa proseso. Sisiguraduhin natin na magiging maayos, bukas at madaling maunawaan ng ating mga kababayan ang prosesong ito. Pagkakaloban, ang magkabilang panig, ang prosekusyon at ang depensa ng sapat at makatarungang pagkakataon upang magharap ng ebidensya, magsuri at magtanong sa mga testigo at mailahad ng buo ang kani-kanilang mga argumento. Sa ganitong paraan, mahiharap sa taong bayan ang malinaw na batayan upang maunawaan ang mga isyong nakapaloob sa Articles of Impeachment. Sa kasabayan ng paghahanap sa katotohanan, ang tungkulin natin tiyakin, iginagalang ang mga karapatan ng bawat panig, lalo na ang karapatan ng respondent Vice President sa isang patas at makatarungan paglilitis. Due process and fair play must remain paramount at every stage of this trial. Let us be firm in the search for truth. Let us remain faithful to the rules of this court, the rule of law, and above all, the Constitution. Nakatutok ang buong sambayanan. Bawat kilos, salita, at pagpapasyang ating gagawin ay huhubog sa kasaysayan. At ang kasaysayan ang huling huhusga kung tayo ay kumilos ng tapat at nararapat. Nais kong bigyan ng katiyakan ng lahat, lalo na ang ating mga kababayan. Gagampanan ko ang aking tungkulin ng patas at may katapatan. Magalang kong hinihikayat ang bawat senator judge Naway ito pa rin natin ang ating tungkulin ng may dangal at pananugatan sa ating konstitusyon upang maging karapat-dapat tayo sa tiwalang ipinagkaloob sa atin ng sambayanang Pilipino. Thank you, distinguished Senator Judges. Pursuant to Rule 2, Paragraph 2 of the Rules of Procedure on Impeachment Trials, as amended, we now proceed to the election of the presiding officer of the Impeachment Court. Senator Judge Panfilo Lacson is recognized for the election.
Point of order, Mr. Presiding Officer.
Yes, we recognize the gentleman from Taguig.
Thank you, Mr. President. Mr. President, Mr. Senate President and Presiding Officer, as the preamble of the Constitution said, imploring the aid of the Almighty God, and as you said yourself, that every stage of this impeachment, we have to make sure na patas, we have to make sure na may due process, we have to make sure that it is fair. It is very clear in the Constitution of the Philippines that the presiding officer is the Senate President. Section 3, Paragraph 6 of Article 11 of the 1987 Constitution, the Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senator shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of 2/3 of all the members of the Senate. I will go to that other 2/3 inquiry later on because this is another threshold issue, Mr. President. But to further the point of order with the indulgence of Senator Lacson so that we can discuss this intelligently. On the final question of whether impeachment, on the issue of who shall preside, under the Constitution, it may seem that it does not say who should preside. But if you look at the records of the Constitutional Commission, number 40, 26 July 1986, the framers deliberately chose the phrase, sorry, Mr. President. I am referring to Section 6, Article 11, and then Constitutional Commission number 41, 27 July 1986. The presiding officer, Mr. Treñas, Commissioner Davide is recognized. Thank you, Mr. Presiding Officer. I have some proposed amendments on Section 3, subparagraph 5. The presiding officer, Mr. Treñas, the gentleman may proceed. Mr. Davide, who later became Chief Justice, this is without prejudice to whatever amendments may be accepted by the committee when the Aquino amendments will be taken up. It would consist in adding a new sentence on line 20 before the phrase, no person shall be convicted, inserted the following, all other cases the President of the Senate shall preside. The presiding officer, what does the committee say? Mr. Munsod, it is not understood, is it not understood that when the President of the Philippines is on trial, it is only time when the Chief Justice of the Supreme Court will preside. It is necessary to say that the Senate President shall decide during all the time. Presiding Officer, Mr. Davide, Mr. Presiding Officer, I precisely presented this because we had a distinction when it comes to the Chief Justice Supreme Court. But with that clarification, that in all other cases, it should be the President of the Senate who shall preside, I withdraw my amendment. So it is but elementary, Mr. President, in statutory, especially construction of the Constitution, that the spirit as well as the letter is followed. The spirit of the Constitution is that it is the Senate President who will preside. This is not an ordinary statement, dictum, or it was not a capricious statement in the discussion, precisely because the Senate President is elected by the majority. As an example, when Senator Pimentel did not like the vote and did not vote with the majority. He offered to resign. So the point, Mr. President, is this. Number one, institutional integrity. We need to protect the legitimacy of these proceedings. Even with the substitute presiding officer acts fairly, a conviction or acquittal reached under constitutionally defective process would invite judicial challenge and cast doubt on the validity of the entire trial. Do we want to go 30 weeks? If we follow the number of days submitted in the pre-trial, 62 and 30, and 3 days every week, so 30 weeks yon. Then after the 30 weeks, we'll end up in the Supreme Court kasi kine-question natin kung tama ba kung sinong nag-preside. Why is it important? Why can't any of the 24 preside? Remember, under our very rules, hindi ko nababasahin para mas umikli. In our very rules, the presiding officer can decide on the spot, or he can throw it to the body, or he can call a caucus or whatever you call it, to be able to decide. And we experienced that during the Corona trial, and that's one reason why everyone acclaimed the late Senate President Enrile, not only because of how he carried it himself, but how the consensus and how he carried it with the minority. Secondly, jurisdiction and regularity. The Senate's jurisdiction over an impeachment trial is constitutional. The exercise of jurisdiction must conform to the Constitution, and the Senate's validity adopted impeachment rules. We cannot say we're following the Constitution, then we will not follow the Constitution. If the Constitution and its framers prescribe who shall preside, who are we to change the Constitution here today? We cannot enlarge or diminish the Constitution arrangement through internal rules or through ad hoc resolution. Lastly, due process. Kailangan malinaw po sa lahat ng partido, both to the prosecution and the defense, kung ano yung korte, kung ano ang two-thirds, kung ano ang charges, kung sino magpre-preside. So kung now, during the first day, we're going to change who's going to preside, and it's against the Constitution, what more changes are we going to do in the next few days? Ano ang limit ng pwede natin palitan sa Constitution at hindi? The authority must come from the Constitution or the governing law, not from the vote of a tribunal. A litigant is entitled to have the case heard by the decision maker, designation by law. The law cannot say that ang mag-hear kay Senator Marcoleta ay Sandigan Bayan, tapos sa Court of Appeals natin siya dadalhin. Hindi pwedeng sabihin sa RTC dapat i-hearing si Juan de la Cruz, tapos sa Sandigan Bayan natin dadalhin. Hindi pwedeng sabihin tatlo sila sa CA, pero in this case, nagbotohan kami, isa lang kaming mag-hearing. Proceedings before a judge or hearing officer who lacks the legal authority are invalid regardless of fairness of the proceedings. A judgment rendered by court without jurisdiction is null and void and may be attacked anytime. It creates no right and produces no effect. It remains basic fact that in law, the choice of the proper forum is crucial, as the decision of a court or tribunal without jurisdiction is a total nullity. A void judgment for want of jurisdiction is no judgment at all. All performed pursuant to it and claims emanating from it have no legal effect. Tan versus Cinco, GR number 213054, June 15, 2016, penned by Justice Perlas Benabe, First Division. The constitutional authority, Mr. President, is very clear. Now, let's put that aside for a moment. But we're not allowed to do that. But for a moment, let's put that aside, that the Constitution is not clear and does not tell us what to do. The rules of the Senate says that any amendment should be presented a day before. And that's why the then minority, when I was Senate President, walked out, because your contention was, when we gave it to the Committee on Rules, kahit mahigit isang araw na at binabalik ng rules, we did not follow the rules. So on the rump session or alleged rump session on June 3, first of all, you did not have a quorum of 13. But let's assume for the sake of argument, I'm not giving you that point. As far as I'm concerned, it's in the Supreme Court, walang quorum on 12. Assuming may quorum on 12, you did not follow the rules. There was not a one-day notice for the rules. And then if you look at the records, this impeachment court adopted the rules on May 18. So that means that it is this impeachment court that now has to adopt any amendment to the rules. We did not debate that amendment to the rule. We cannot now just change the rules. We're here for the opening statements. We're here for the trial. Are we here to change the rules? We're changing the rules here today, Mr. President. So, Mr. President, later on I'll ask permission to talk about yung two-thirds because both the issue of the presiding officer and the issue of what constitutes two-thirds of all members is a threshold issue. Para maintindihan lang po ng lahat, lalo po sa mga kababayan natin na nanonood, Merriam-Webster, simple definition, a threshold issue is a preliminary question, minimum requirement, or foundation condition that must be met or resolved before proceeding to the substantive merits of a case, project, or process. In this initial criteria, if this initial criteria is not satisfied, further action is typically dismissed or halted. I want to avoid that this impeachment trial will be declared null and void. I want to avoid walkouts. I want to avoid any delays, Mr. President. The Senate President is more than capable. He said he is willing. He said he is ready. He has been in many situations in his life that people say you cannot do it, but he is done well. He has studied. So what is the issue? Why do we have to vote for a presiding officer, Mr. President? Why can't we follow the Constitution? So the point of order, Mr. President, is that amending the rules, implementing a null and void rule, and violating the Constitution will endanger this whole hearing, Mr. President. So please rule on the point of order, and I hope that the Senate President, who is more than able, will preside.
Thank you to the gentleman from Taguig. Before I express my views on the matter, let me just put into the record the facts on when we amended Rule 2 of the Rules of Procedure on the impeachment trials. On June 3, 2026, Senator Juan Miguel Zubiri proposed Senate Resolution number 430, and that was adopted during that time. And then, on the same day, the same resolution was adopted and renumbered to Resolution number 40. It was published on June 9, 2026, in the Philippine Daily Inquirer, as well as Malaya. During that time, in June 3, when we amended the rules, everyone had the opportunity to express their views regarding the proposed resolution. And since no one objected, we adopted Resolution number 430 and renumbered it to Resolution number 40. That is anchored on our Constitution, Article 6, Section 3, Paragraph 8 of the Constitution, that the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. So my view to the good gentleman, let me just finish, sir. My view is this resolution has been duly approved, and everyone was given an opportunity to discuss that, to object. However, it was no one objected to that resolution, and it was duly approved by the body. So any discussion regarding this resolution should be discussed in plenary when the Senate convenes as a legislative body. In the past precedents, during the era impeachment, November 15, 2020, the body as well approve the rules of impeachment in plenary. During the Corona impeachment, March 23, 2011, once again, resolution number 39 was adopted in plenary. So any issues pertaining to this resolution should be discussed in plenary when the Senate convenes as a legislative body. So that is the position of the chair and the view of the chair on this matter.
Sir President, first, may I dispute that you used the word fact. It is not a fact that the rules were changed because it is being disputed that first, there was no quorum at that day. Second, if we are going to amend the rules of impeachment for the impeachment trial in plenary under the rules of the Senate, Section 136, second paragraph says, the rules may be amended by means of a motion that should be presented at least 1 day before its consideration. It was not presented on June 2. So, we did not follow our rules. So, a rule that was passed that did not follow our rules or amendment that was passed that did not follow our rules is void. You cannot get anything out of it. It is a nullity. So, if today we pass a change in our rules, and we do not follow our own rules in changing that rules, we cannot follow that rules. Secondly, Mr. President, the impeachment court already adopted our rules. Iba po ang plenary, tama po kayo doon, I agree with you there. Iba po yung impeachment court. So is the impeachment court now hostage or subject to whatever changes the legislative body does and we will not adopt? Then why did we adopt the rules when we took our oath? We adopted it because the impeachment court is not powerless to talk about our rules. But finally, Mr. President, for the sake of argument, just for the sake of argument, wag na natin tignan yung mga amendments. It's against the Constitution. So can the impeachment court disobey the Constitution? If the Constitution says the presiding officer should be the Senate President, can we now say na no, pagbotohan natin kung sino? Because if we say that we can, what next? Will we add to the articles of impeachment? Will we lower the bar of the quantum of evidence needed? Will we say that baliwala na yung pre-trial brief at bahala na si Batman? So, Mr. President, I thought that's why we have the rules. Because when we have the rules, it dictates fair play. And the rule says, it is the Senate President who will preside. So if now we're not going to follow the rules, anong pinag-uusapan natin patas? Anong pinag-uusapan natin due process? Anong pinag-uusapan natin na fairness? It is, who we chose as Senate President is a political. So we made our case doon na we would have a more fair. You made your case, you got the majority. Now you got the majority, we will give you all the support, Mr. President. But we have to follow the Constitution. We cannot have a trial where we do not follow the Constitution, Mr. President. I think pinaka-basic po yun. Saan sa Constitution po nakalagay, Mr. President, that ang nakalagay dito po, only in case the President. Let me give you a hypothetical. God forbid, God forbid. God forbid may mangyari sa Pangulong Marcos. Maging Pangulo ngayon po, si Sara Duterte. My view is tuloy yung impeachment. Pero, ang magpre-preside na yung Chief Justice. O pwede ba tayo magbotohan na wag yung Chief Justice ang, wag yung Chief Justice ang mag-preside? So how is it possible that today, we're starting out on the wrong foot by arguing who will preside when the Constitution already settled it, Mr. President? So I appeal to my colleagues. There are a lot of accommodations, there are a lot of things, may bigayan talaga dito. May botohan, may caucus, may in-camera discussions, pero pagdating kung sino magpre-preside na malinaw sa konstitusyon, wag na natin pag-awayan yon. The prosecution is here, I think they're ready. The defense is here, I think they're ready. Let's give the Filipino people, a fair trial. Hindi po fair kung pipiliin natin kung sino ang kahit sinong magaling, kahit ako piliin nyo. Hindi ko po tatanggapin yon kasi mali po yon. Hindi po yun ang nakalagay sa Constitution natin. Very, very clear po sa records ng Constitutional Commission. Walang makaka-amend doon. We are not given any latitude on this matter, Mr. President. I appeal to you, Mr. President. This is your Senate presidency.
Thank you. Thank you for that, those views to the good gentleman from Taguig. Kanina po, nabanggit ko ho na in my manifestation as the Senate President, that resolution number 39, or the rules of procedure on impeachment trial, as amended, shall continue to apply. So in other words po, rin-recognize ho nitong impeachment court yung amendments na ginawa ho natin noong June 3. At kagaya ho ng nasabi ko kanina, the humble view of this presiding officer is if there are any discussion on resolution number 43, as adopted as resolution number 40, it should be done in plenary. Because doon ho natin in-amend yung, doon ho natin in-adopt yung impeachment, rules of impeachment, doon rin ho natin inamendahan. At nabigyan naman po ng oportunidad ang bawat isa para magkomento, magbigay ng pahayag, magbigay ho ng kanilang legal opinion. Pero at that time, wala naman po ang nag-object at inadapt po ng Senado in a legislative body. So the position of the chair, if there are any comments, any legal opinions, any issues, it should be done through the legislative body of the Senate.
Mr. President, there is no conflict, Mr. President, with your permission, Mr. President. There's no conflict. If you want to discuss it, in 3 weeks may session na tayo. So all we have to do today is follow the Constitution. You preside, then pagdating ng plenary, then we can debate whether we are allowed to amend the Constitution or not. Because, Mr. President, that's why I premise this not as a parliamentary inquiry or as a point of information or whatever we may call it. That's why it's a point of order. A higher point of order than the point of order in the rules is a point of order in the Constitution. The Constitution says it is the Senate President who will preside. So are we saying now, Mr. President, that the rules can amend the Constitution? Is that the ruling of the chair?
Before I make my final ruling on this matter, may I recognize the gentleman from Pampanga, Senator Kiko Pangilinan.
Thank you, Senate President. Mr. President, with all due respect, the Constitution does not provide that the Senate President must preside in cases of impeachment trial. What the Constitution provides is that when the President is undergoing impeachment, going through the trial, is being tried, the Chief Justice must preside. Nowhere in the Constitution, in the provisions on public accountability and impeachment, does it say that the Senate President must preside when the Vice President is under trial or any other impeachable officer. And precisely because of this, and precisely because the Constitution likewise allows Congress, not the impeachment court, Congress, to promulgate its own rules, which is what the Senate did in June 3. We proposed amendments to the rules under our rulemaking power, which, by the way, was subsequently ratified when we convened in a special session on June 17. The June 3 journal was ratified unanimously on June 17 when we had our special session. And in the June 3 minutes and the journal, precisely, we approved the amendments to the rules. This was further ratified on June 17. Therefore, it is considered regular. The presumption of regularity now comes into force. But having said that, Mr. President, the good gentleman from Taguig has brought this matter before the Supreme Court. And we agree with the point earlier raised by the Senate President. This matter should be either discussed in the Senate in plenary as a legislative body, or if he has questions which may in fact turn out to be valid, he has brought this matter before the Supreme Court. And therefore, this impeachment court is not the venue for this debate, Mr. President. If there is anyone who is out of order, with due respect, I think the proper process is the matter is pending before the Supreme Court. There is no temporary restraining order. There was a request for a status quo ante order. It was not granted. And therefore, the presumption of regularity behooves us as an impeachment court to proceed. And finally, Mr. President, allow me to reiterate, the point of order is improper. In fact, the debate on this matter here in the impeachment court is out of order, Mr. President.
Sir
For the record.
President. Sir President,
So
before you decide, Mr. President.
the chair has already
Sir
ruled.
President, before you rule,
The chair has
Senator
already
Pia wants
ruled.
to ask for the floor.
Just 2
And
minutes.
may I respond to
May
Senator
Well,
Pangilinan?
allow the gentleman from Taguig to rebut for 2 minutes, and then we will make the final ruling.
Before I rebut, I'm from Ateneo Law School, and what they taught us there is that you look at the records of the Constitutional Commission, and then pag klaro, klaro. But let's call someone from UP Law to see whether they were taught the same thing. Senator Pia, may I ask that Senator Pia be
We
recognized
recognize the
before I
gentle
get my
lady
2
from
minutes?
Taguig, Senator Pia Cayetano.
Thank you, Mr. President. It's not an Ateneo UP issue, but always happy to stand before our colleagues and share our experience in the UP College of Law. I was prepared to address this to all our members of the bar in the Senate, but since it is Senator Kiko, my schoolmate, my teammate actually in the UP volleyball varsity team who stood up, I'll also specifically address it to Senator Kiko. So dear Senator Kiko and our colleagues in the majority, knowing that you have members in the majority that are lawyers, and for those who are not lawyers, you definitely have consultants who are lawyers. Wala naman siguro ni isang senador dito na walang consultant na abogado. Kahit ako abogado, ang dami ko hong staff na abogado din. Why? Because these are legal issues. We need to talk to the experts. Kung pag-uusapan natin ang mental health, physical health ng Vice President, then of course we will not listen to lawyers. We will listen to doctors, di ba? So this is a legal issue. Let's hear what the lawyers have to say. But let me just quote, because I know the Senate President doesn't have time to call on all the lawyers. So if you ask your lawyers in your staff, I'm sure nag-abala sila to look at the constitutional records, to look at the journal. I'm sure. And if they did not, please take your cell phone now and text your staff. What does the constitutional journal, the records of the debate show? Sinabi na po ni Senator Alan Cayetano, you can question him, you can doubt him, ask your staff. May I ask you, dear colleagues, let's do our job well. The same way when you stand up and you tell me to do my job well and you disagree, I disagree with your point of view, I will listen intently to your point of view. And I'm looking at each one of you because this is our solemn duty. What does the Constitution say? Nakalagay doon, the Chief Justice, pag the President. Silent nga po sa iba. So sabi ng iba, at yan ang sinasabi ng Senate President natin na mukhang pwedeng iba. So we looked at what the constitutional framers said. What did they say? Nagdebate na po sila, colleagues. Nagdidebate tayo dito. Pag sinabi ng sponsor, ito na yung paliwanag, yung nag-i-interpolate at nagbibigay ng amendment, sinasabi niya, okay, yung pala paliwanag mo, okay na ako. No need to amend. Yun at yun din ang sinabi. Let's place ourselves in that position. Because that happens to us every day. Every day, somebody stands up and says, ano ibig sabihin nito? And the sponsor will explain. Pag hindi maliwanag, sasabihin nung nag-i-interpolate or nag-a-amend, ay, papa-amend ko kasi hindi maliwanag or I want to improve it. Pero kung nagkaintindihan naman, okay na. Eh yun nga yung binasa, tanungin nyo naman po yung staff nyo. Or let's pause, let's all get a copy. Let's show it. Because this is the foundation of this trial na tama yung nakaupong presiding officer. So that's my first point. Mag-abala naman tayo. Read it yourself, ask your staff to print a copy. In fact, on that note, may I ask Senator Allen's staff to print a copy and give it to all our colleagues. Mabilis lang yan, hindi na yan mapapatagalan. Show it. We can take judicial notice naman po siguro of it. Siguro naman, alam na natin ang ibig sabihin ng judicial notice. You can go to the actual records. Nandito na makakuha naman natin yon kung pagdududahan nyo yung ipapaprint ko. So that's my first point. My second point, Mr. President, is addressed to His Honor. If His Honor will insist that we have to call a regular session, we have to be in session to amend the impeachment rules, eh di tawagan niyo po ang Malacanang. Nagpa-special session naman po siya, di ba, with all due respect, to pass the National Orchid Law. To pass, what else? Anong tatlo yun eh? Oo nga, yun nga, yung waling-waling as National Orchid. Ano pa yung dalawa? No, I know, I'm not questioning it. I'm saying that there was a special session called to pass 3 laws. Naalala ko yung waling-waling because I love it. This is important. O ano pa yung dalawa? Unfortunately, hindi ko na maalala. Dalawang naturalization. Sports-minded po tayo. Love po natin yan. Nagkaroon ba ng laban between now and July para mag-special session tayo para doon? Hindi ko alam. But in any case, ito importante ito, di ba? Eh di kung pa-i-insist nyo na yung impeachment amendment na yan kailangan gawin ng special session, eh, papatawag tayo ng special session. Mukha namang very supportive naman ang Malacanang sa majority. Di ho ba? Pero I take the position that we are in impeachment court. We are already in impeachment court. Therefore, the amendments must happen here. Medyo common sense din naman po yan. I rest my case. Yun lang po. But as soon as the copies come, I will give it to you. Colleagues, look at it. Huwag tayong majority-minority botohan. Ayusin natin yung pagboboto natin dahil pinapanood tayo, pinapaniwalaan tayo, at umaasa sa atin ang taong bayan. Maraming salamat po.
Once again, it is, again, before the chair rules, let me acknowledge a former Senate President, Senator Tito Soto.
Thank you, Mr. President. Tama-tama yung sinabi ng distinguished lady from Taguig. Tanungin daw yung mga legal staff. Binigay nga sa akin ng legal staff ko, eksakto ganito eh. Article 11, Section 6, page 154. Constitution is silent regarding presiding officer of Senate impeachment. However, the Constitution expressly provides that the Chief Justice will preside if President is on trial. O ngayon, yung mga graduate ng Ateneo at saka ng mga UP, ito ngayon yung legal maxim. Expressio unius et exclusio alterius. In other words, the express mention of one thing is the exclusion of another. Palagay ko, naintindihan nyo lahat ganyan. Itong akin, sa publiko yung sa akin. Ang sinasabi ng publiko ngayon, nanonood sa atin, dapat you should not resort to too much technicalities kasi ang public interest ang iniisip nila rito. They want to expedite the proceedings. They want the trial, not rules. They're interested in the trial, not rules. In the interest of justice, sabi nga nila, sometimes rules are not sacrosanct. But itong nangyayari ngayon dito, ang publiko ang importante rito. Where does the Constitution emanate from? From the public, from the people of the Republic. So, desisyonan nyo na to, Mr. President, para matapos na.
Mr. President, can I have my 2 minutes?
Once again, let me reiterate the position of the chair. My humble position is that this matter should be discussed during plenary when the Senate is convened as a legislative body. And may I ask the gentleman from Taguig if he is objecting to this position?
Yes. I'm objecting to the position and will call for a vote. May I explain? I think under the rules I can explain why I'm asking
We'll
for a vote.
call for a vote first, and
Mr.
then
President,
we'll allow...
Mr. President, under the rules I can explain why I'm calling for a vote first so that I can convince them to vote for me.
No, under the rules,
When you object,
there's an
Mr.
objection, the vote will proceed without any explanation.
President,
and after that,
under the
we will
rules-
allow the gentleman from Taguig to explain his vote.
Mr. President,
So we call for
Mr. President,
a division of the
President.
House. So those who are
Sir President, Mr. President, when you
Wait,
object,
no,
you're
no.
allowed to explain your objection and state
Senator
your
Lacson
objection.
is recognized.
Thank you. Your Honors, pursuant to Rule 2 of the Rules of Procedures on Impeachment Trials, as amended, I move to elect Senator Judge Francis Joseph Guevara Escudero as the presiding officer of this impeachment court.
Objection, Mr. President, and may I allow to...
We proceed to
Objection,
the-
Mr. President.
The Senate tackles the issue on the impeachment court's presiding officer. Okay, napahaba dun sa start. What's your take on this, Attorney Edwin?
It's too long. It's too long. I don't understand why they're debating on a presiding officer.
Well, I have to say, kasi clear naman sa Constitution that when the President is undergoing the impeachment trial,
It's a
it's
Senate-
the
it's a
Chief
Chief
Justice of the
Justice.
Supreme Court. Pero wala naman doon nakalagay na pagka ibang officer, kailangan ay ang Senate President ang presiding officer, except nandun siya sa impeachment rules
Right.
ng Senate.
Under the records of the Constitutional Commission, Hilario Davide made a proposal that in cases of impeachment of the President, his amendment was the Supreme Court shall sit as a tribunal. That was rejected. And ultimately, the only thing that was agreed upon by the Constitutional Commission was the Chief Justice should sit when the President is on trial. Beyond that, there's no mention as who will be the presiding officer. By inference, because the most senior is the Senate President, that's why ginawa rin na rin ng Senate impeachment rules that the Senate President. But they can always change the rules.
Yeah, and I think that's what Senator Alan Peter Cayetano is now contesting, kung valid ba yung pag-amend nila ng rules through Senate Resolution number
Correct.
43. Mamaya, interesting to, tanong natin
Okay,
si former Senate President Frank
expert tayo.
Drilon. Oo, di ba? So coming up, we'll speak with former Senate President Franklin Drilon.
Kasi
Looking for the perfect escape? Discover Club Nalu, a serene beachfront retreat where stillness meets style. Nestled along the quiet shores of Bacnotan in La Union, Club Nalu is designed for slow mornings, ocean breezes, and moments that help you unwind. From cozy rooms and sun-drenched villas to relaxing spaces inspired by nature. Every corner invites you to pause, breathe, and recharge. Club Nalu, come as you are and leave feeling a little lighter. Book now at clubnalu.ph.
welcome back. You're still watching BNC's special coverage of Vice President Sara Duterte's impeachment trial.
Joining us now in the studio is a former senator judge in the Estrada and Corona impeachment trials. Please welcome former Senate President Franklin Drilon. Good afternoon, Senate President Frank.
Hi, good afternoon, Karen. Good afternoon, Edwin.
Boss, so, narinig mo yung debate.
Kanina, we were expecting
Yeah.
doon na tayo sa entry of appearance and then opening statements. Pero natagalan because of this whole issue on who
Yes.
should be the
Yes.
presiding officer.
As you know, as explained in the debate, the Constitution only specifies that it shall be the Chief Justice who should be the presiding officer in case it is the President of the Republic who is on trial. The rest of the situations are not covered, and therefore the Senate could promulgate rules. Now, The Senate, in its rule, said the Senate President shall preside over sessions.
This is the Senate Rules of Impeachment,
The
right? That
Senate
currently
rules of
exists.
impeachment,
Oo.
yes. It said the President of the Senate. Now, but now they have designated, they're probably Chis Escudero. Now, so the issue is, can they do that?
Right.
Yes, they can do it because this is not provided in the Constitution. It is only in the rules of the Senate. And when they will elect or have elected Senator Chis Escudero, in effect, they have suspended the Senate rules, which says that it is the President of the Senate who shall preside over the impeachment trials where the impeached officer is not the President. As simple as that.
And on that point, SP Frank, let's go back to the Senate because mukhang nagka-development na on that issue. Let's see who they elected as the presiding officer of the impeachment trial. Okay, we're seeing a live video here no of the impeachment trial. O nag-recess na
nag-recess.
sila. Pero ang breaking news ngayon is that they did proceed to elect Senator Chis Escudero as the presiding officer.
That's right.
Oo. So ngayon importante na yung issue. Legal ba yun?
Yes. Boss, yung sinabi kanina ni Alan, he's mentioning na there should have been a day before.
One day notice to amend the rules.
This is an amendment to the rules. They were electing a presiding officer in accordance with the rules. If I recall correctly, they're allowed to do that.
But SP Frank, just to take a step back, if I follow the argument of Senator Alan Peter, what he's saying is that the Senate impeachment rules that they have existing right now says that it's the Senate President that should preside over the impeachment trial.
Yes.
But what the current Senate did was they amended this through Senate Resolution number 43 by saying that they can elect who the presiding officer would be. But Senator Alan Peter is saying, but you amended that without a one-day notice in accordance with the rules. So he's saying the amendment is questionable.
Yeah.
But si Senate President Gatchalian said, okay, if you're questioning that, dapat sa plenary to pag-usapan when we're sitting as a legislative body. Do you agree?
Alam mo, hindi ko na rin naiintindihan sa dami ng argumento eh. Now, but my point is this. How will the people look at this?
Right.
How will the people look at the impeachment trial as a venue for finding out what is the truth? And the impeachment trial is supposed to exact accountability for impeachable officials. Umpisa pa lang nagdidebate na kung sino magpe-preside. It's a sad commentary. And you expect this kind of the debate for the next several weeks when the impeachment trial will take place. This kind of question will always raise two sides. Whether or not Chis Escudero can preside. To me, that's beside the point. Ang hinahanap po ng taong bayan dito sa impeachment trial, kung ano po ang katotohanan. In a survey conducted by, I think, Okta.
Yeah.
8 out of 10 Filipinos said they would like to know the truth. Ayun bang kung sino magpe-preside is that finding the truth? Hindi eh. So, my suggestion to my colleagues is, decide on it, put it already as having as a done deal or a settled issue, and proceed with the trial, rather than get bogged down with all of these technical.
SP, is Alan preparing to go before the Supreme Court? Nang aga-aga pa lang, he's already questioning so many things.
Yeah. Well, sinabi
You
niya nga
expect that from
foundational
the
daw
minority.
yung... you can expect that from minority.
Well,
yeah.
of course, you
Okay.
expect that.
But
right
we
away.
But Attorney Edwin, ano ba ang concern if it's Senator Chis Escudero that will preside? Kasi ako naman, nagulat lang din na nag-iba because from what I remember last week, nagsalita na si Senate President Gatchalian that he will be the presiding officer for the impeachment trial. But now that it's changed, why? What's the big deal? Anong palagay niyong major concern?
I don't know. The first time I hear all these things this afternoon.
Is it possible, SP, that they preferred Chis Escudero because he's a lawyer, because this takes on a character of a judicial process.
Possible. Anything is possible here. And, at the end of the day, every issue will be ruled upon initially by the presiding officer, but ultimately by the impeachment court itself. So I don't really see the point of the debate, because at the end, it will be the Senate 24 or the senator judges who will decide on an issue, not the Senate President. Although initially he will be ruling on it, but ultimately, if there is any question, it is the body that will preside. So, bottom line, I find the debate useless.
Well, SP Frank, makibalita tayo dun sa nangyayari sa Senate. Joining us on the line is Hannah T. from the Senate. What's the latest, Hannah?
Yes, Attorney Frank, nag-suspend nga ang impeachment court ng proceedings pansamantala sa gitna noong naging debate between Senate President Win Gatchalian and Senator Alan Peter Cayetano because of the objection of Senator Alan on the voting na nangyari na naghalal kay Senator Chis Escudero bilang bagong presiding officer ng Senate Impeachment Court. Balikan ko na lang din yung nangyari kanina na after the debate, si SP Win, he ruled that the body should proceed under the amended rule nga kung saan binoto rin itong si Escudero eventually na nag-object itong si Senator Alan. At at matapos niyan, meron siyang inihayag na isang information that he received allegedly na meron daw personnel ng AMLA na for him ay umakyat daw sa opisina ni SP Win at nagkaroon ng conversation kaugnay ng pagbubukas or posibleng pagbubukas ng bank accounts ni Escudero. Kaya ito rin yung partly reason why he objects doon sa naging botohan kanina. Kung matatandaan natin, Attorney Karen, Escudero is among the flood control figures na ngayon ay nahaharap sa allegations na bahagi umano siya ng kickback scheme. Pero so far doon sa nakikita natin sa Senate plenary ngayon, sineset up na itong rostrum para makaupo itong si Senator Escudero bilang presiding officer. Pero nandito tayo ngayon sa labas ng Senate plenary, hinihintay natin makapagpa-interview sa mga nandito. Andito si Attorney Lorna Kapunan. Pakinggan natin yung interview sa kanya.
Before we hear the interview, Hannah, of Attorney Lorna Kapunan, let's go back inside the Senate and see what's happening because the trial has just resumed.
Trial, it is the only time when the Chief Justice of the Supreme Court will preside. Is it necessary to say that the Senate President will preside during all other times? Ulitin ko yung tanong, kasi yun ang tanong natin today. Is it necessary to say in the Constitution that the Senate President will preside during all other times? Ang sagot ni Mr. Davide, Mr. Presiding Officer, I precisely presented that because we have a distinction when it comes to the Chief Justice of the Supreme Court. But with that clarification, that in all other cases, it would be the President of the Senate who will preside, I withdraw the amendment. Kaya clear sa Constitution that in all other cases, the President of the Senate will decide. Wala, hindi ho applicable dito yung excluso unos. Hindi ko na-memorize yan kasi I graduated in 1991 and we took that up in 1987, but the phrase is, pag hindi kasama, excluded. Hindi po applicable yon. With all due respect to our former Senate President, it is the intention of the framers that matter. I will ask the page to help me distribute this among our colleagues.
Okay.
Senator,
so, go ahead.
Senator Drilon,
Attorney
the mention
Edwin.
of Senator Pia Cayetano citing the constitutional records But it's also a principle of statutory construction that these records are only persuasive.
Yeah.
and
It's the
cannot-
letter of the law that should prevail, right? Kung ano yung lumabas sa final version ng
Yes,
Constitution.
the wording of the law.
Yeah.
Yes.
Correct.
So, again, Edwin, I find this debate nothing to do with finding the truth, which is the purpose of the impeachment trial. But, you know, they're superior in judgment. They are senator judges, so we are at their mercy insofar as the proceedings are concerned.
But what can they do in order to secure the credibility of the proceedings? Because umpisahan ng sabihin ni Senator Alan Peter Cayetano kanina na pag hindi natin sinunod yung rules, maaari tayong ma-question yung validity ng proceedings all the way up to the Supreme Court. But of course, what we want to avoid is precisely that, na after all the proceedings, bigla i-question sa Supreme Court. What can they do at this point just to iron out any questions
Well,
that...
if you cannot iron it out, rule. And the majority rules in a collegial body like the Senate, and let those who disagree question it for the Supreme Court. But you cannot get bogged down with the disagreements that you see and get bogged down insofar as the trial is concerned. That's all I'm
My
saying.
concern, Senator Drilon, is does this constitute grave abuse of discretion that will allow Supreme Court to interfere? Because this is a decision judgment of the Senate as a body.
In my view,
Yes.
the Supreme Court cannot intervene in this
Correct.
particular case because under the Constitution it's very clear that the impeachment court shall be the sole authority, underscored sole authority, on the impeachment trial or to try and decide cases in impeachment court. So the Supreme Court cannot cite its
Extraordinary statutory powers.
Jurisdiction.
Right.
Because this is very specific. It's the
Right.
impeachment court. So, in my view, they should, they have already ruled. Senator Cayetano obviously does not agree with this. So, the court should proceed and go to the trial. If Senator Cayetano feels that it is wrong, then let him go to the Supreme Court. That is his right.
Yeah.
to
But they
question.
can pass. So assuming ang basis ng pagtanong ni Senator Alan Peter Cayetano is Senate Resolution number 43, which amended the Senate rules on impeachment to allow a different presiding officer other than the Senate President. They will convene as a legislative body in how many days from now? A few days from now, right?
After SONA.
Oh, after SONA. So can
June
they
SONA.
not just have those rules amended in accordance with the procedure that Senator Alan Peter is insisting on, that there's a one-day notice, and then they amend it, and would that then have a retroactive effect to cure yung pag-elect kay Senator Chis Escudero as the presiding officer?
Under that proposal, in effect, you suspend the impeachment trial until you're able to amend the rules, and the rules can be amended only by the Senate asking as a legislative body and convene as such, which is after the SONA. So in effect, what the proposal is to suspend all the proceedings.
Can they not proceed and then ma-retroactively affirm yung pag-appoint na lang kay Senator Chis Escudero as the presiding officer? Is that something they can do?
It's something that they can consider. The point is, I don't think they should get bogged down with all this debate.
But Senator Drilon, that was precisely what Senator Pangilinan was saying. We're not acting as a legislative body now. So wasn't that some sort of giving in? Because he was saying hindi tayo legislative body ngayon.
What he was saying is, if there are any objection or amendment to the rules, it should be
At the plenary.
presented to the Senate
Yes.
as a legislative
Yeah.
body.
In the meantime, tuloy tayo.
In the meantime, tuloy tayo. Because we are,
okay.
Yeah.
that's what he was
But
saying.
where are they coming from kaya? Baka meron ba tong kinalaman sa mga decisions on admissibility? Because under the Senate rules on impeachment, the presiding officer rules on the materiality, admissibility, relevance, and competence of the evidence. So baka para sa kanila, meron ng prior prejudgment si Senator Chis Escudero that the others are counting
don't
on.
Forget, don't forget that any ruling of the chair is appealable to the body. And therefore, or the presiding officer just makes an initial ruling. If other senators do not agree with it, he can appeal to the floor.
Okay, and on that note, SP Frank, tignan natin kung nag-move forward na itong impeachment trial on day 1. Let's go back to the live proceedings at the Senate.
The intent of the framers of the Constitution. And today, we disregarded the intent of the framers ng Constitution. Magandang hapon po. Gaya ng pag-uumpisa ng hearing na ito.
We know the remarks of Senator P in connection with their explanation of vote. What is the pleasure of Senator Judge Soto?
I'd like to explain my vote also, Mr.
The
President.
gentleman may proceed, and he has 2 minutes.
I have
Kindly
one
be
line.
mindful of the timer.
I have one line to say. That's the reason I voted in favor. Because the minutes of the Constitutional Commission are merely research source.
What is the pleasure of the Honorable Padilla?
Ginoong,
Will the gentleman explain his vote?
opo.
The gentleman may proceed. You have 2 minutes, sir.
Maraming salamat po, Ginoong punong tagapamahala. Mga mahal kong kasama, sa loob po ng 4 na taon na ako po ay ibinoto ng ating mga kababayan at nagsilbing senador, ako po ay naging tagapangulo ng komite ng Constitutional Amendments. At tuwing meron pong pagdinig, ang lagi po naming pinapatawag ay yung mga sumulat ng konstitusyon. Bilang sila po ang nakakaalam kung ano ang puso, ang diwa ng konstitusyon. Malinaw po na kung meron tayong pakikinggan, yung creator. Hindi po ba? Tayo naman po lahat ay naniniwala sa Panginoong Diyos, kaya tayo po ay naniniwala sa salitang creator, tagapaglikha. At ang lumikha po ng konstitusyon ay itong mga taong nabanggit sa ipinamahagi ng ating mahal na Senadora Cayetano. Malinaw po dito. Nasabi na po sa English ito. Mainam po ay sabihin po natin sa Tagalog upang mas maintindihan po ng ating mga kababayan. Humingi po ako ng tulong sa Google kasi legal terms po ito. Hindi naman po ako nagtapos sa UP, hindi rin po ako nagtapos sa Ateneo, nagtapos po ako ng criminology at UP rin sa University of Prison. Ang sabi po dito, sa Tagalog po Ginoong Presiding Officer, eksakto ko itong hinihain dahil nagkaroon tayo ng pagkakaiba pagdating sa punong maestrado ng Korte Suprema. Ngunit sa paglilinaw na iyon, na sa lahat ng ibang mga kaso ay ang Pangulo ng Senado ang mamumuno. Kaya binabawi ko ang nasabing susug. Ang nagsabi po nito ay ang dating Justice Davide. Ngayon, mga mahal kong kasama, at sa ating po mga taga-subaybay, ang batas po ay precise. Hindi po ito pwedeng iba-ibahin o baluktutin. Kung ano ang sinabi lalo ng saligang batas, ay sana po ay panghawakan natin. Ngayon, sa loob po ng 4 na taong ko dito, lagi pong sinasabi yung tradisyon. Minsan, yung rules na yan, nawawala yan Ilang beses na ako naguluhan dito dahil, teka, sundin natin yung tradisyon kaysa yung rules. 2 beses na po nagkaroon ng impeachment. Yung unang impeachment, ang nag-preside ay yung Chief Justice. Kung kay Pangulong Estrada. Yung sumunod po, nandito na po ako nun. Ang nag-preside ay ang mahal na Bicolanong kaibigan ko, Senador Chis Escudero. Yun po kasi yung nasasabi sa saligang batas at tradisyon. Yun na po yung nangyari. Ngayon, gusto ko pong tanungin yung mga kasama ko sa majority. Personal na tanong po ito. Nung hinihikayat po akong sumama sa majority, isa lang ang sinabi ko. Kung si Senator Chis Escudero, ang kababayan kong Bicolano, ang gagawin yung Senate President, lilipat ako sa inyo. Ang hindi ko maintindihan, bakit ngayon pinipilit natin na ang ating presiding officer si Chis Escudero? Ba't hindi natin siya ginawang Senate President nun? Yun lang po ang tanong ko. Maraming salamat.
The remarks of the gentleman is noted. Senator Marcos, what is your pleasure, ma'am? The lady may do so. You have 2 minutes, ma'am. Kindly be mindful of the clock.
Yes, thank you very much. Ang sabi sa atin ng bata tayo, kapag mali ang umpisa, mali na ang lahat na susunod. Ayoko naman magkamali sa umpisa pa lamang na napakahalagang paglilitis na ito. Unang-una, paulit-ulit na nating sinaad na ang ating saligang batas ay hindi maaring baluktutin. At napakaklaro nito. At ang sinasabi ng ating Constitution of 1987, Article 11, Section 3, Number 6, all other impeachable officers, ang sinasabi, carving out therefore the exception that proves that rule, that the Chief Justice is the single exemption, and otherwise the presiding officer should be the Senate President. It is the exception that proves the rule. Palibasa na uso ang Latin, may kabaliktaran din sa kinote ni Senator Soto, expressio unius est exclusio alterius. Palibhasa, hindi naman in-exempt, ibig sabihin na laging dapat ang Senate President ang presiding officer. Ikalawa, nakita naman natin ang mga debate, ang listahan ng mga sinabi at paliwanag nung dating Chief Justice natin, si Mr. Davide, nung panahon, nung convention. Contextual reading and the thorough debate do not allow for any interpretation whatsoever, and we should abide by that. Ikatlo, yung kaduda-dudang quorum nung June 3 na pinapaliwanag ng aming minority leader na hanggang ngayon nakatenga pa rin. Kung tutuusin, nung sinasabing na amyenda, yung Supreme Court petition ay pending pa, kaya hindi karapat-dapat na yon ang sundan. Ikalima, it's not the impeachment court but the Senate that amended the rules. Kaya para sa akin, napakaraming dahilan. Huwag sana nating sayangin itong napakahalagang responsibilidad natin at huwag mag-umpisa sa mali itong paglilitis. Maraming salamat.
Thank you, Senator Marcos. Duly noted and entered into the records. The pleasure of Senator Legarda. Senator Judge Legarda, rather.
Thank you, Mr. Presiding Officer. Where the Constitution is
The
silent...
lady will explain her vote or make a manifestation.
It's a manifestation. Which,
The lady may proceed with her
seems like an
manifestation. She has 2
explanation of
minutes.
vote. Thank you. Where the Constitution is silent, the intent of the framers should guide the choice of the presiding officer. Any departure from the traditional arrangement must be approached with caution, as it may place the validity and the legitimacy of the entire impeachment in doubt. Mr. Presiding Officer, I also respectfully place on record that there is a pending challenge before the Supreme Court involving the June 3rd Senate proceedings, including the authority of the body then that adopted Senate Resolution number 430. This manifestation is made to place on record that we are not yielding our position in the pending case and is without prejudice to the final determination of the Supreme Court. Thank you, Mr. Presiding Officer.
Thank you, Senator Legarda. The presiding officer would like to make a statement.
Sa mga ginagalangan kong kapwa Senator Judge, sa ating mga minamahal na kababayan, sa mga partido sa kaso na kabinbin ngayon sa Senado, isa pong maganda at pinagpalang hapon sa ating lahat. Sa araw na ito, muling gagampanan ng Senado ang isa sa mga pinakasagradong tungkuling iniatas ng saligang batas. Ang pag-upo natin bilang isang impeachment court para litisin at husgahan ang pangalawang Pangulo. Kinikilala ng ating saligang batas na may mga opisyal na may hawak ng kapangyarihan at pananagutan na napakabigat para sa kanila lamang itinakda ang impeachment bilang tanging paraan para sila ay panagutin. Article 11, Section 2 of the Constitution enumerates these officials: the President, the Vice President, the members of the Supreme Court, members of the Constitutional Commissions, and the Ombudsman. They are not ordinary public officers. According to the late former Senate President Juan Ponce Enrile, they hold, quote, the highest and most sensitive offices of government. They may be removed from office only upon conviction for offenses of the highest constitutional gravity: culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of the public trust. Impeachment is a means to preserve constitutional government through the removal and disqualification, if so warranted, of an unfit official from a position of public trust. 5 opisyal pa lamang ang na-impeach ng Kamara de Representantes sa ating kasaysayan sa ilalim ng 1987 Constitution. Una, si dating Pangulong Joseph Estrada noong 2001 na ang paglilitis ay naungusan ng mga pangyayaring humantong sa EDSA 2. Ikalawa, si Ombudsman Mercy Gutierrez noong 2011 na nagbitiw bago pa man mabuksan ang kanyang paglilitis ng Senado. Ikatlo, si Chief Justice Renato Corona noong 2011 din na nilitis na patunayang nagkasala at inalis sa tungkulin ng impeachment court bilang punong mahistrado. Ikaapat, si dating COMELEC Chairman Andres Bautista noong 2017 bagamat nagbitiw siya sa pwesto bago pa man mapadala ang Articles of Impeachment sa Senado. At ikalima, si Vice President Sara Duterte noong 2025. Subalit ang nasabing Articles of Impeachment ay idineklara ng Korte Supremang null and void ab initio kung kaya't ito ay inarchive ng Senado. Siya ay muling na-impeach sa kasalukuyang taon at ngayon naharap sa paglilitis na ito. Ipinakikita lamang na maikling talaan nito na ang impeachment ay hindi isang pangkaraniwang kaganapan. Turing nga ng Korte Suprema, quote, it is the most difficult and cumbersome mode of removing a public officer from office. Subalit, ang paglilitis na ito hindi lamang hindi pangkaraniwan, ito ay tunay na bukod tangi. Bakit? Una, si Vice Presidente Sara Duterte ang kauna-unahang opisyal na 2 beses na na-impeach ng mababang kapulungan. Pangalawa, siya ang kauna-unahang Vice Presidente na haharap sa paglilitis ng isang impeachment court at pangalawang opisyal lamang na halal ng sambayanan na sasailalim sa prosesong ito. Pangatlo, siya ay hinahalal ng may pinakamalaking mandatong pinagkaloob ng sambayanang Pilipino sa sinumang kandidato sa ating kasaysayan. Mahigit 32 milyon o 61% ng kabuuang boto para sa ikalawang Pangulo. Pang-apat, ang Articles of Impeachment laban sa kanya ay inendorso ng 277 na miyembro na kumakatawan sa ating mga mamamayan mula sa iba't ibang distrito at sektor at ng ating bansa, na katumbas ay mahigit 80% ng kabuuan ng Kamara de Representantes. Terminating an elected mandate before the end of its term is among the most drastic acts our constitutional democracy can undertake. This is why the trial must be guided with prudence, tempered by caution, and marked with unquestionable impartiality. We must avoid even the appearance of impropriety and observe the cold neutrality of an impartial judge at all times. May I therefore caution my fellow senator judges, the prosecutors, the respondent, and their respective counsels and witnesses to refrain from making any comments and disclosures to the public pertaining to the merits of this trial as mandated by the impeachment rules itself. Let us heed the words of the Supreme Court that said, "Impeachment is not a chance to settle political scores. It is not a stage for political theater or personal attacks, because when the focus shifts to the person rather than the alleged wrongdoing, the process loses its integrity." As presiding officer, I shall do my part to uphold the fairness and integrity of this process and shall see it through to its proper conclusion. At this point, I would like to thank my colleagues for their trust and confidence. I did not seek nor did I ask for this responsibility, but neither will I shirk from fulfilling this duty without fear or favor. This now brings me to the threshold questions that will guide the conduct of this trial and the rulings of the chair. First, what is the number of votes needed to convict the respondent? Second, what is the quantum of proof required to sustain a judgment of conviction or acquittal in these proceedings? Third, how strictly or liberally will this court apply the rules in resolving questions of procedure and evidence? On the first issue, the Constitution provides that no person shall be convicted without the concurrence of 2/3 of all the members of the Senate. With 24 members of the Senate, a literal interpretation of this means that conviction requires the affirmative vote of at least 16 senator judges. This literal interpretation finds direct support in the 2000 case of Bayan versus Zamora, which concerned the Senate's compliance with the 2/3 vote required to concur in a treaty. Despite having only 23 incumbent senators at that time, then Senator Gloria Macapagal Arroyo was elected as vice president. Therefore, there were only 23 senators. The court held the charter provides that the Senate shall be composed of 24 senators. Without a tinge of doubt, 2/3 of the figure, or not less than 16 members, is an unquestionable compliance with the requisite number of votes mentioned in Section 21 of Article 7. It behooves, therefore, all of us to observe the same fidelity with the Constitution in this trial, which affects not only the mere ratification of a treaty, but more so affects the substantial rights of the respondent, as well as the sovereign will of the people as expressed in the overwhelming mandate given to her. This is the prevailing law today. Whether we agree with it or not, we must abide by it. However, those who disagree are not without recourse, because this is without prejudice to the right of any party who holds a different view to seek judicial relief. And should the Supreme Court, who possesses the sole authority to interpret the Constitution by virtue of its power of judicial review, render a different ruling on this question other than what the chair has stated, this court and this representation shall faithfully abide by that ruling of the Supreme Court. On the question of quantum of proof, given that impeachment is a sui generis constitutional proceedings, the standards of proof that govern administrative, civil, and criminal proceedings do not apply. However, this does not mean that senator judges shall rely solely on their conscience in deciding this case. No less than the Supreme Court also said that, quote, decisions regarding whether to acquit or convict must be based upon clear charges supported by sufficiently clear and convincing evidence. Furthermore, let me be clear that the burden of proof in these proceedings rests upon the prosecution. It does not and will not shift. The respondent is afforded the presumption of innocence and has no obligation to disprove the charges against her. Finally, we turn to the application of the rules of court in these proceedings. Rule 1, Section 6 of the Rules of Courts provide that the rules shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. We are also guided by the Supreme Court's Bench Book for Trial Judges, which reflects a long-standing principle of adjudication. In case of honest doubt about the admissibility of evidence, it is a better policy to rule in favor of admission and let the senator judges decide whether to give it little or no weight when deciding upon the case in the final outcome. But let me be clear. A liberal construction of the rules is not a license to ambush the opposing party, bypass due process, or introduce unverified evidence that would prejudice the fair and orderly conduct of this trial. Accordingly, consistent with the demands of due process, fair play, and the orderly administration of justice, the chair will construe the rules liberally so that, number one, the prosecutors may be able to adequately present their case, that the respondent may be able to rigorously test it. Number three, that the senator judges may be able to weigh the evidence for themselves. And fourth, so that the Filipino people may hear the whole and impartial truth regarding the allegations against the Vice President. Let us remember what our oath requires us, to do impartial justice according to the Constitution and the laws. Hindi po tayo nandito upang itaguyod ang anumang pampolitikal na adyenda. Hindi tayo narito upang paglingkuran ang kagustuhan ng alinmang panig. Narito tayo upang alamin ang katotohanan at sa pamamagitan nito, mapairal ang hustisyang walang kinikilingan. Ang tungkulin natin bilang mga hukom ay hindi maaaring talikuran. Sa gitna nito, batid ko ang mga problemang kinakaharap ng ating bayan na patuloy natin dapat pa ring pagtuunan ng buong pansin at hanapan ng solusyon. Tayo ay mga senador bago tayo umupo bilang mga hukom at mananatili tayong mga senador na patuloy na magsusumikap na tugunan ang mga pangailangan ng ating mga kababayan bilang Senado at hindi mababago ito. Kaya't aking hiling at dalangin na huwag sana malunod ang diwa ng pagkakaisang nagpigis sa atin, gaano mang katindi ang mga debate at pagtatalo sa hukumang ito. Dahil anuman ang magiging kalabasan ng paglilitis na ito, laging kinakailangan ang Senadong nagkakaisa. Dalangin ko po na sana pagkalubad tayo ng katatagan, karunungan, pagpapakumbaba at pag-unawa upang magampanan nating lahat ang ating tungkulin bilang mga hukom. Pagpalain na po lahat sana tayo ng poong may kapal. Maraming salamat at magandang hapon.
So let's go back to Senator Drilon.
What?
So, what do you think of the whole situation? Why did they allow all these statements made by the minority senators? For the record purposes lang?
I don't know. You see, this is something new to me, where, each senator, or at least a number of them, were allowed to express their views. At the start of the trial, I thought that we were going on an impeachment trial, but, this is, as they said, the impeachment trial is sui generis.
And they're living up to that
and
reputation.
They're living up to that reputation.
Yeah.
So, that's all I can say.
Senator Escudero laid down already his ideas. For instance, the quantum of votes, 16 votes. Does it settle the issue of it can be lowered because the absence of the other senators?
I take a different view. You cannot interpret the law to the point of absurdity. Okay, if you say that the 24 is the immovable number from which you draw 2/3, what if 9 senators are out of the country or have resigned or are incarcerated? How do you convict? You mean the process of impeachment as a process to exact accountability can no longer work? That is the result if you just peg it at 16.
But the Senate would have the power to also use their compulsive power
Coercive,
to arrest or to bring the
sige,
senators to court para
How do you use your
discharge their
compulsive
duties.
power on somebody who cannot be found?
But that's Senator Bato.
Yes.
But that's only one person, right?
How do you propose to utilize your compulsory power to somebody who is not in the country? How do you propose to use your compulsory power to someone who has quit?
How about for someone arrested, Senator Drilon?
Sorry?
For someone arrested like Jinggoy and
Or single,
Marcoleta?
yes.
Can't they request for leave of court sa Sandigan
They
Bayan
can.
to allow them to
They
participate?
They can do that. But the discretion is with the court whether to allow them or not. That is not the discretion of the Senate.
Okay. So
Because-
you're saying itong
Yeah.
16 vote requirement that's currently provided under the Constitution, maari pang pag-usapan or it can be legally
16
debated
is
about?
not provided in the Constitution.
It's two-thirds votes of
Two-thirds
all,
vote.
yes. I was basing it on the number of 24.
yes.
Yeah, 24
Because based on your
senators.
theory, if you lower the denominator to, for instance, 21,
Yes.
because there will be 3 who were absent, the two-thirds now would only be 14 votes.
That's correct. Yes.
So if you do that, let's say if they, but already Chis Escudero has mentioned 16. Can the members of the body, if they gathered 14, overrule
Of course.
the presiding officer?
They have, that is the view of Senator Escudero. We respect his view, but there is another school of thought which says that you cannot interpret it to the point of absurdity, where even if, less than 16 senators are left, you still require 16.
But is it up to the Senate Impeachment Court to decide on that number, or is this something that should be decided by the Supreme Court?
Well, ultimately, it will be decided with the Supreme Court because, assuming just theoretically that 14 votes, there are only 14 votes to convict, that said guilty, the prosecution will assert that the impeachment process resulted in the impeached official is guilty and therefore should be dismissed. Now the Supreme Court will have to rule on that because I am sure that the defense will assert otherwise.
Yeah.
So ultimately, it's in the Supreme Court.
And SP Frank, you've already participated in 2 impeachment proceedings, one of former President Joseph Estrada and then of former Chief Justice Corona. What would be your advice to the presiding officer? Well, in this case, it's Senator Chis Escudero.
Well, my advice is remember that the people are looking for the truth.
Right.
Remember that that in a certain survey, 8 out of 10 Filipinos said so. Remember that the question on the second envelope resulted in EDSA DOS. So all these things are too recent in our minds to be set aside. And what am I saying? To the senators, be conscious that the people are watching, that they would not want the truth to be covered. And you'll never know what will happen next. As nobody predicted EDSA DOS, but because the second envelope was hidden in the view of the people, that's the reaction was what resulted in EDSA DOS. So what I'm just saying is, the Senate must project impartiality and that they are after the truth because they will be judged by history. So that's how it goes. They were elected in the Senate. Unfortunately, there is this episode in our political life where they are directly involved. So each to his own.
Thank you so much, Senator Frank Drilon, former Senate President and former Senator Judge in 2 impeachment trials.
I have a master's degree.
Yes, in impeachment, which is why you're here. Thank you again so much for your insights.
Thank you,
Sana po
Senator
kayo magsawa.
Pleasure.
Balik
Thank you
kayo
very
dito.
much for having me here.
For now, we'll pause for a break. Stay tuned to BNC's Vice President Sara on Trial, a BNC impeachment coverage.
Wherever there is opportunity, there are Filipinos.
There are many Filipino first stories here throughout North America. Tinitingala na ngayon ang Bilyonaryo News Channel bilang tulay between the Filipino stories in the Philippines to the Filipino stories here in North America.
And wherever there are Filipinos, Bilyonaryo News Channel follows to deliver stories that they need to know and to serve the ones who also serve at the expense of leaving home. Thank you for the warm welcome, North America. This is BNC, your Bilyonaryo News Channel. The wait is over.
Hello everyone and welcome to the bigger, better and bolder Bilyonaryo Quiz Bee Season 2.
From top universities and colleges, the nation's best young minds compete for over 2 million pesos worth of prizes.
From the University of the Philippines din naman. From Ateneo de Manila University.
De La Salle University.
From the University of Santo Tomas.
San Beda College, Alabang.
From Far Eastern University. From Pamantasan ng Lungsod ng Maynila. FU Alabang. From University of the Philippines, Manila.
Who will will rise above the rest and become the next Quiz Bee Milyonaryo. Bilyonaryo Quiz Bee Season 2, College Edition.
And I'll be your next Quiz Bee Milyonaryo.
Coming soon on the Bilyonaryo News Channel.
So I think you should find fulfillment in different areas of your life because life is holistic, right? Kailangan buo siya.
Gusto ko sana talaga my way. And hindi ko talaga habol kung sobrang magkaroon ako ng trending na song. Gusto ko mahanap ko yung audience ko. Kung sino nakaka-relate sa songs ko, kung sino nakaka-relate sa gaga.
Now, I just like to help our community. I want to give back to the community. Yun yung parang it makes my heart more happy na. Kasi not because I have everything, but it's because I know kung paano yung wala.
Being a Filipino is not necessarily about geography. It's about whether you have pride in helping the Filipino people, whether you have the heart, the character, the actions, the desire to really represent the Philippines. So.
Welcome back. You're still watching BNC's special coverage of Vice President Sara Duterte's impeachment trial.
We now have in the studio the former Dean of FEU Institute of Law, Attorney Mel Santamaria. Kumusta din?
Buti naman at napapanood natin ngayon yung impeachment.
Matanong ko lang, nagturo ka rin sa Ateneo, di ba?
Turo ako sa Ateneo, tagal na.
Estudyante mo ba si...
Oo nga pala, naging UP versus Ateneo
Senator,
kanina.
yes, naging estudyante ko si Senator Cayetano. Yeah, Senator Cayetano, Senator Bam Aquino. Tsaka sino pa ba dyan?
Sa Katipunan si Bam?
No, hindi, sa Ateneo.
Nag-law ba siya?
Nag-law siya first year. Kasi,
I didn't know that.
pero nung second year, na-appoint siya ni Ramos dun sa chairman of the Youth Commission.
No, GMA yun, NYC.
O something like that.
Oo.
So, doon na siya nagpunta.
Okay. And marami ring mga UP law sa senator judges eh. We have Senator Pia Cayetano and Senator Cheese Escudero, mga UP law naman. But what is your take on yung pinagtalunan na presiding officer?
Yung presiding officer.
Yes, that issue.
Well, madami naman desisyon ng ating Korte Suprema patungkol sa rules ng Senate o ng Kongreso. Ang pinakamaganda na dyan, yung Pendaton Osmeña versus Pendaton. Sabi ng Korte doon, pwedeng gumawa ng rules ang Senate. Okay? Meron silang rules of the Senate, pero pwede ba nilang baguhin kahit kailan? Sabi ng Korte Suprema, oo, pwedeng i-abolish, i-waive, or i-modify, provided that the quorum is existing. Because a deliberative body who made their own rules can at any time revoke its own rules, provided a quorum exists.
Which they clearly have here
Yes,
right
which they
now.
clearly have. Kaya hindi ko malaman kung ano pa yung pinagdedebatehan.
So, ibig sabihin, kahit na hindi na-follow yung previous one day muna.
No, pero hindi, Attorney Edwin, kasi nga kini-question ni Senator Alan Peter na nung time daw na inamend yung rules, hindi valid yung quorum nila.
Dahil walang quorum.
Pero
yun ang question ko. To what extent will...
Yun ang spirit ng Pendaton versus Osmeña.
Okay.
Sinabi nila, any irregularity in procedure is not a vested right, provided that the people who are responsible for that rule has a quorum or have a quorum, then so be it. Because
so
that
you
is the
mean later
legislature.
on. But so to what extent can a question on the presiding officer affect the validity of the proceedings?
Well, for me, wala. Because if they elect a presiding officer and there is a quorum which elected that, then you come into the doctrine of separation of powers. They are supreme within their own domain. And so that therefore, sabi ng Korte Suprema, aside from the separation of powers, yun na nga, no, provided that there is quorum, nobody has a vested right, even the senator, on their own.
Doon sa sinasabi ni Alan Cayetano kasi na walang quorum yun eh.
Yes.
I mean, sinabi niya, 12 lang kasi sila. But remember, diba, if it's an ordinary course of business, the quorum depends on the number of senators present that day.
Yes, exactly.
May 12 sila.
Majority of the quorum will prevail.
Correct.
Majority of the quorum will prevail.
That's why they're saying...
So you're saying that yung
the Sherman
amendment
Black's
that they
claiming
did,
there is majority because they were 12 at that time.
Senate Resolution 430
She's
should
provided
have
the
been...
12th number.
Yes, and they applied Cuenco versus Avellino versus Cuenco, which says that anybody who is within the coercive power of the Senate can be considered as
Okay.
president.
And now let's go back to the Senate. We're now seeing at the podium si Congresswoman Jervil Ruistro. So tignan natin kung nasa ang stage na ngayon ang day 1 of the trial.
Your Honor, the entire 15 private prosecutors have filed already their written entry of appearance with the impeachment court. The articles of impeachment will be presented by 4 separate teams, Your Honor, and that explains why the House prosecutors or the panel of prosecutors are joined by 15 private prosecutors, Your Honor.
Noted. Thank you, ma'am. Senator Cayetano, what is the pleasure of the lady from Taguig?
Yes, Mr. President, I just have a question for the prosecution panel. I understand that there is no requirement for the members of the House who form part of the prosecution to be lawyers. But may I know if they are all lawyers, and if some are not, may we know who are not lawyers? Thank you.
Your Honor, all the 11 House prosecutors are members of the legal profession.
Does that satisfy the senator judge?
Yes, I was just curious, Mr. President, because it's not a requirement, so I was just curious if, in fact, they are lawyers. Thank you.
Duly noted. The response of the lead prosecutor is duly noted.
Your Honor, may I just enter a correction to the earlier manifestation?
The lady may proceed.
Instead of 13, 14 private prosecutors are able to enter their appearance today. Nonetheless, all the 15 have filed their written entry of appearance with the impeachment court, Your Honor.
Noted. Appearances for the respondent.
Good afternoon, Your Honors. I am Sheila Sison, respectfully appearing for Vice President Sara Zimmerman Duterte. With the permission of the court, my co-counsel will enter their respective appearances.
You may proceed.
Gregorio Y. Narvasa II.
Christine R. Ferrer for the Vice President.
Good afternoon, Your Honors. Michael Wesley Poa for the Vice President.
Good afternoon, Your Honors. Carlo Joaquin T. Narvasa for the Vice President. Good afternoon, Your Honors. I am Mark C. Vinluan for the Vice President.
Good afternoon, Your Honors. Justin Nicole B. Gular for the Vice President.
Good afternoon, Your Honors. Lyndon Miguel C. Bacuel for the Vice President.
Good afternoon, Your Honors. I am Ralph Borja Bodota for the Vice President.
Good afternoon, Your Honors. Roberto Narvasa Batungbakal for the Vice President.
Good afternoon, Your Honors. David Runel M. Gully VII for the Vice President.
Good afternoon, Your Honors. Carl Grace G. Oroseo for the Vice President.
Good afternoon, Your Honors. Clarlene Raddock for the Vice President.
Good afternoon, Your Honors. Francesca Marie V. Flores for the Vice President.
Good afternoon, Your Honors. Miguel Carlos Albar Fernandez for the Vice President.
Chair notes the entry of appearance of the counsels for respondent Vice President Sara Zimmerman Duterte, and Chair likewise notes that the Vice President is not physically present but represented more than adequately by her counsels who entered their appearance. On May 19, 2026, the court, pursuant to Rule 7 of our rules, issued the summons to Vice President Sara Zimmerman Duterte to answer to the articles of impeachment. On May 20, 2026, the Sergeant at Arms served the summons on the Vice President and made a return of service under oath before the Secretary of the Senate. Let the return be entered at large into the records pursuant to Rule 8 of the Rules of Procedure on Impeachment Trials. So ordered. Likewise, the court received pleadings, comments, manifestations filed by the parties. All such pleadings, comments, manifestations, and requests filed by the parties, as well as all issuances and orders of the clerk, as well as the clerk of court, made through the presiding officer, are hereby deemed read into the records of the case. So ordered. At this juncture, the chair would like to direct the parties to prepare for their opening statements. We will start with the prosecution. May I know from the prosecution who will deliver the opening statement, and from the respondent who will deliver the opening statement? Under our rules, only one lawyer shall deliver the opening statement for either side. I presume, Representative Luistro, you will deliver for the prosecution and for the on the part of the respondent?
I will deliver the opening statement for the defense, Your Honor.
Representative Luistro from the panel of prosecutors of the House of Representatives is now recognized to deliver her opening statement for the prosecution. You may proceed, ma'am, and you have 15 minutes.
Your Honor, before I proceed, the prosecution respectfully moves for the reading of the 4 articles of impeachment and the entry of the corresponding answer or plea for each article of impeachment, Your Honor. Your Honor, this is consistent to the Senate rules on impeachment, particularly Rule 7, Your Honor, the last paragraph of which mentions about failure to appear, failure of the lawyer to appear, and failure to file answer. There should be an entry of plea of not guilty. Likewise, Your Honor, under Rule 9 of the Senate Rule of an Impeachment, which says that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. In this rule, Your Honor, it was likewise provided that the name of the person appearing in behalf of the respondent should be entered into the record. And by the answer, Your Honor, it is humbly believed that it pertains to the particular plea of whether guilty or not guilty of the respondent, Your Honor. Likewise, Your Honor, under Rule 21, Your Honor, the trial of all the articles of impeachment shall be completed before the senators vote on the final question of whether or not the impeachment is sustained. It is gleaned from these rules, Your Honor, that the senators will be voting on a per-article basis, Your Honor. And that is why it is the humble submission of the prosecution that there should be reading of the article and entry of the particular plea per article, Your Honor. This likewise, Your Honor, manifests our complete adherence to the mandate of the Constitution sa pagbasa po ng mga artikulo ng impeachment at pagpapasok ng sagot ng respondent. Maipakita po natin sa sambayanang Pilipino ang ating pagsunod sa mandato ng Konstitusyon. Likewise, Your Honor, it upholds due process not only of the respondent but also of the Filipino people. Sa pagbasa po ng mga artikulo ng impeachment, she will be informed of the nature of the accusation against her bago pa po siya sumagot whether she is guilty or not guilty, Your Honor. Likewise, Your Honor, ang 4 na artikulo po ng impeachment ay nakabase sa iba't ibang alegasyon ng facts at iba't ibang nature of accusation or cause of action, Your Honor. And with that, Your Honor, it is perceived that there is a possibility that the plea of the respondent to each and every article will be different from one another, Your Honor. And lastly, Your Honor, this is consistent with the Senate rules on impeachment because the senator judges, the honorable senator judges, Your Honor, will be voting on a per-article basis after the conclusion of the trial of this impeachment case, Your Honor.
The chair will respond. Unless the counsel for respondent would like to say something about the motion of the distinguished lead prosecutor.
Yes, Your Honor, may I comment?
The lead, you may proceed.
Before the presiding officer can rule on the motion or request of the lead prosecutor. But before I give my comment, may I just clarify if the lead prosecutor is now making a motion to arraign the respondent accused.
Your Honor, whether this is arraignment or otherwise, the motion of the prosecution is very much consistent with the Senate rules on impeachment.
I think the question, Your Honor, is very simple.
As I have
It's
mentioned, Your
answerable by
Honor,
yes or no, Your Honor.
Rule 7,
is the lead prosecutor,
Rule 9,
is the lead prosecutor
Let this not be a debate between the
requesting
counsels.
for the respondent accused to
Counsel
be
for
arraigned, Your Honor.
respondent, kindly make your comments and avoid asking questions from the counsel for the prosecutor. We will recognize the counsel for respondent for her comments on the motion and the manifestations made by the lead prosecutor for the House. You may proceed, ma'am.
Thank you, Your Honor. I believe I have a standing question to the lead prosecutor, and I would like to ask her for the legal basis for requiring the respondent to be arraigned today. Because, Your Honor, I note that in her request earlier and manifestations given for the respondent to be arraigned today, she cited Rule 7, Rule 9, and Rule 21. However, in Rule 7, it very clearly states that if the person impeached after service shall fail to appear either in person or by counsel on the day so fixed, or appearing shall fail to file his answer to such articles of impeachment, the trial shall proceed nevertheless as upon a plea of not guilty. Well, this rule is clear. It does not talk about any arraignment. And if we take a look at this sentence, everything here has been satisfied. The respondent accused is here, has attended through counsel. She may not be in person, but the notice given to the defense is that she may appear through counsel. Second thing is that the respondent accused was also able to file her answer. And so Rule 7 does not support the request of the lead prosecutor that the respondent accused be arraigned today. Now, on the matter of Article 9, counsel also say that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. And if he or she appears, or any person for him or her, the appearance shall be recorded, stating particularly if by himself or by agent or counsel, naming the person appearing in the capacity in which or he appears. If he or she does not appear, either personally or by agent or counsel, the same shall be recorded. And for all intents and purposes, respondent is present today through counsel. There is also nothing in Rule 9 that requires the reading of a 23-page articles of impeachment, which will be a waste of judicial time. Now, finally, under Rule 21, Your Honor, may I just correct the manifestation earlier by counsel, because it would seem to me, unless a reading of the transcript would say that I'm mistaken, but I seem to have heard the lead prosecutor claim that the voting on the articles of impeachment will be per article. Well, that's true, but the first sentence of Rule 21 says, the trial of all the articles of impeachment shall first be completed before the senators vote on the final question on whether or not the impeachment is sustained. Now, honestly, I do not see how Rule 21 is related to the motion now being requested or propounded by the lead prosecutor. And at any rate, Your Honor, given that the respondent is represented by her counsel today, and this is consistent, her appearance is consistent with the notice given and in accordance with the rules on rules of procedure of this court, then we can enter her plea on her behalf.
The arguments of the parties are duly noted. Chair will now make its ruling. The articles of impeachment were deemed read and spread into the records when it was referred by the Senate to the Committee on Justice for the proper issuance of summons. And a plea of not guilty will only be entered in accordance with our rules in behalf of the Vice President if she does not file an answer. But in this case, she has filed an answer and in fact has appeared through counsel. Insofar as the reading of the articles of impeachment is concerned, it will be done at the final resolution of this case when it is put to a vote by the senator judges, where each article of impeachment will be read before a vote shall be taken thereon. For those reasons, the motion is denied, and the lead prosecutor, Representative Luistro, may proceed with her opening statement kindly be mindful of the clock. And before recognizing you, ma'am, may I remind the counsels for the parties to kindly address the chair with respect to anything and everything they want or wish to say before the court, and not to address each other. The lady may proceed. Representative Luistro, you are recognized, and you have 15 minutes for your opening remarks.
We thank the court, Your Honor.
Mr. Presiding Officer, the Honorable Cheese Escudero, the Honorable Senate President, Honorable Win Gatchalian, sa atin pong mga kagalang-galang na Senator Judges, mga minamahal na kababayan, sa loob ng bulwagan o sa labas man, mga nakatutok sa telebisyon, sa cellphone o sa radyo, sa ang sulok man ng mundo, kayo naroroon. Maraming Pilipino ang nagtatanong ngayon, bakit mahalaga ang paglilitis na ito? Ano ang kaugnayan nito sa buhay ng ordinaryong Pilipino? Lubos po naming nauunawaan ang mga tanong na yan. Sa katunayan, may isang driver na nagtatanong, paano sasapat ang kita sa pasada upang mapakain niya ang kanyang pamilya? May isang OFW na nagtatanong, hanggang kailan kailangan lumayo upang mapaaral niya ang kanyang mga anak? May isang guro na nagtatanong, paano pagkakasyahin ang kanyang sahod sa dami ng utang na hinuhulugan? May isang manggagawa na nagtatanong, hanggang kailan magtitiis sa pansamantalang trabaho at kakarampot na sweldo? Sa unang tingin, maaring sabihin na malayo sa buhay nila ang paglilitis na ito. Ngunit hindi. Hindi po. Sapagkat ang usapin ngayon ay patungkol sa isang bagay na pag-aari nilang lahat. Ang kanilang pera, ang kanilang tiwala, ang kanilang karapatan na maningil ng pananagutan mula sa mga pinuno na kanilang pinagkatiwalaan. Kapag ang isang empleyado ay nagkamali ng paggamit ng pera ng kumpanya, siya ay pinagpapaliwanag. Kapag ang isang barangay treasurer hindi maipaliwanag ang nawawalang pondo, siya ay iniimbestigahan. Kapag ang isang principal ay naglustay ng pera ng bayan, kahit 5,000 lang yan, siya ay pinaparusahan. Natural lamang na magtanong ang sambayanan kung ang ordinaryong Pilipino ay pinapanagot. Bakit hindi ang pinakamakapangyarihan na opisyal ng pamahalaan? Ito ang dahilan kung bakit mahalaga ang paglilitis na ito. Hindi upang usigin ang isang tao, hindi upang maghiganti sa kalaban, hindi upang manalo sa politika, kundi upang sagutin ang isang tanong na napakahalaga sa kinabukasan ng ating republika. May saysay pa ba ang pananagutan sa ating bansa? Sapagkat ang kasong ito ay higit at lampas sa sino mang opisyal. Higit at lampas sa anumang partido. Higit at lampas sa alinmang administrasyon. Your Honors, the framers of the Constitution understood that there may come a day when extraordinary power would be entrusted to extraordinary office. They also understood that there may come a day when trust would be broken. And that is why they gave the House of Representatives the power to impeach and the Senate the duty to judge, not to punish political opponents, not to settle political scores, but to protect the republic itself. That is why the Constitution declares public office is a public trust. Ang kapangyarihan ay hindi pag-aari ng sino mang opisyal. Hiram lamang ito sa taong bayan. At ito ang dahilan kung bakit naririto tayo ngayon. Your Honors, the prosecution will present exactly what the Constitution requires. Evidence. Hindi chismis. Hindi haka-haka. Hindi propaganda. At lalong hindi SOCMED narrative. Evidence. Official records. Financial documents. Government reports. Video recording. Statements under oath. Independent findings of institutions created by law. Mga dokumento na hindi bumoboto. Mga records na walang partido. Mga katotohanan na walang kulay pampolitika. Sa unang tingin, maaring magmukhang magkakahiwalay ang 4 articles of impeachment. Confidential fund, unexplained wealth, bribery and corruption, threat against constitutional order. But these are not 4 separate stories. These are 4 chapters of the same story. Story about power exercised without accountability. Story about public trust betrayed. Story about public office that stopped answering to the public. On the first article of impeachment, the evidence will show that more than 612 million pesos in confidential fund entrusted to the office of the Vice President and the Department of Education were disbursed, transferred, and liquidated under circumstances that cannot withstand scrutiny. 612 million pesos. Hindi ito pera ng gobyerno. Pera ito ng sambayanan. Pera ng manggagawa. Pera ng magsasaka. Pera ng OFW. Pera ng guro. Pera ng bawat Pilipino na nagbabayad ng buwis at nagtitiwala na gagamitin ito ng tama. The evidence will show liquidation reports supported by questionable documents. The evidence will show acknowledgement receipts bearing names government records could not verify. Names that transformed accountability into a mockery. Pananagutan na naging kalokohan. Names that insulted the intelligence of the Filipino people. Mary Grace Piatos, Milky Sikuya, Kokoy Villamin. On the second article of impeachment, the evidence will show financial transactions involving billions of pesos associated with the respondent and her husband. Billions. Hindi milyon, bilyon. At habang milyon-milyong Pilipino ang nagtratrabaho at nag-iipon buong buhay upang magkaroon ng sariling bahay, makapagpaaral ng mga anak, magkaroon ng kaunting seguridad para sa pamilya. Aba, bilyon-bilyong piso ang dumaan sa mga bank accounts na hindi maipaliwanag ng maayos. This article is not about wealth. This is about accountability. This is about explanation. If wealth was lawfully acquired, where is the lawful explanation? If transactions were proper, where is the complete accounting? If numbers truly add up, then why do they refuse to reconcile? On the third article of impeachment, the evidence will show bribery, graft and corruption through the distribution of cash payments and monetary gifts to officials under the supervision of the respondent. This article is not simply about envelopes. This is about institution. This is about whether loyalty was purchased rather than earned. Government cannot function if loyalty is purchased instead of earned. Kapag nabibili ang katapatan, nawawala ang integridad. At kapag nabibili ang opisyal, nabubudol ang bayan. Perhaps the greatest tragedy is where the conduct allegedly occurred. In the Department of Education. Tama po sa DepEd. The institution entrusted with teaching future generations honesty, responsibility, integrity. On the fourth article of impeachment, the evidence will show culpable violation of the Constitution, high crime, betrayal of public trust through conduct that threatens constitutional order. Among all allegations before this court, none strikes more directly at the heart of constitutional order than this one. Ito na po ang pinakamatindi. And unlike in many cases, which depends upon competing accounts, this evidence comes substantially from the respondents' own recorded public statements. The court will see them. The court will hear them. The court will judge them. Public officials may disagree. We may criticize one another. They may compete fiercely for power. That is democracy. But democracy ends when violence begins. Sa kasaysayan ng ating republika, walang vice presidente na may kaibigan na hitman. Ngayon lang. Walang vice presidente na nagpapapatay ng Pangulo. Ngayon lang. Walang vice presidente na handang magpapatay para lamang makaupo sa pwesto. Ngayon lang. The Constitution provides many means on how to resolve political conflict. Election, legislation, public debate, judicial review, and even impeachment. But it does not permit threats. It does not permit violence. It does not permit people entrusted with power to place themselves above constitutional restraints. Your Honors, at the center of this case lies a simple question, perhaps the most important to any republic. When the people entrust power to a public official, does the public official remain accountable to the people, or do the people become accountable to the public official? The Constitution's answer is very clear. Power belongs to the people. Public office is merely borrowed. And every borrowed power carries with it the obligation to account for its use. If a barangay treasurer must account for public fund, then so must the vice president. If an ordinary public servant can be investigated, then so can the highest officials of the government. If ordinary citizen is expected to obey the rules, then surely those who govern them must obey them first. Otherwise, what lessons do we teach our children? That there is law for the powerful and another for everyone else? That accountability exists only for the weak? That public office grants immunity against accountability? Your Honors, this is not the republic envisioned by the Constitution. This is not the republic deserved by the Filipino people. Therefore, The prosecution asks only this: look at the evidence. Listen to the witnesses. Examine the records. Follow the evidence wherever it leads. Judge this case not by politics, not by popularity, not by fear, not by loyalty. Judge this case by the Constitution. Judge this case by the evidence. Years from now, future generations will not remember today's political alliances. They will not remember today's headlines. They will not remember today's slogans. What they will remember is when accountability was tested, the institutions of the Republic stood firm. They will remember only one thing: what this court did when the Constitution called. Future generations will not ask how powerful the respondent was. They will not ask how loud the political debate became. But they will ask one thing: when the Constitution called, did the Republic answer? Your Honors, this is that moment. This is the moment the Constitution anticipated. This is the moment when accountability must mean exactly what it says. This is the moment when public office must truly remain a public trust. This is the moment when the Republic must demonstrate that laws are applied equally to the powerful and the powerless alike. At matapos marinig ang mga saksi, matapos masuri ang mga dokumento, matapos matimbang lahat ng ebidensya, ang prosekusyon ay naniniwala at naninindigan. Isa lamang ang maliwanag na konklusyon: ang tiwalang ipinagkaloob ay nilabag. Ang kapangyarihang ipinahiram ay inabuso. At ang konstitusyon mismo ang humihingi ng pananagutan. Amid the clarity of the mandate of the Constitution, political noise continues. Political squabbles continues. Political division continues. Please, let me conclude. Salus populi est suprema lex. The welfare of the people is the supreme law. Thank you, Your Honor.
The opening remarks of the prosecution through the lead counsel is duly noted. Opening remarks for the respondent. Counsel for respondent has 15 minutes, and we will give you the same latitude we gave counsel for the prosecution for an additional 3 minutes, should you so need it. You may proceed, ma'am.
Thank you, Your Honor. Your Honors, fellow Filipinos, good afternoon. As we begin today the impeachment trial of the Vice President, and in the days ahead, this court will undertake its constitutional task of receiving and weighing the parties' evidence, and ultimately to decide whether these pieces of evidence justify either a judgment of conviction or acquittal, guided only by its members' conscience and their solemn oath to do impartial justice. The present undertaking of this court, therefore, not only carries the weight of the Constitution, but also the imprint of our nation's history, because the Filipino people have shown that they never forget. We, as a nation, never forget. But why is the act of remembering important? What does it matter to our history and to ordinary Filipinos? Because in this trial, the prosecution proposes that we unseat the Vice President elected to office by more than 32 million Filipino people, more than the number of votes cast for the sitting president, and much greater than any of the votes secured by each of the members of the House of Representatives who now are here to prosecute her and seek to undo this people's choice. Sa makatwid, ang malinaw na layunin sa likod ng mga paratang na ito ay ang pagpapatalsik sa isang vice-presidenteng inihalal ng mahigit 32 milyong Pilipino at bunga ng kanilang malayang pagpapasya. Whatever one's political persuasion is, the reality is that the prosecution now comes before this court to remove a vice president chosen by an overwhelming number of the electorate. You all have heard the prosecution say repeatedly that this is because they seek accountability, that the people have a right to hold their leaders accountable. This is not a matter of debate. Indeed, the people have a right to demand accountability from their leaders. What we have yet to hear from the prosecution, however, is this. When the Constitution declared under Section 1, Article 11, that public office is a public trust and that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives, the Constitution does not only speak to the Vice President. It also demands the same standards from the prosecutors. Being public officers themselves, the public prosecutors and the members of the House of Representatives are also held to the same constitutional standard. And so we must remember what history tells us. This is not the first time that members of the House of Representatives have attempted to remove the Vice President, and in a manner not compliant with the Constitution. In a July 25, 2025 decision, the Supreme Court unanimously declared in Duterte versus House of Representatives, GR numbers 278353 and 278359, that the impeachment proceedings in the House of Representatives were tainted with grave abuse of discretion, rendering the articles of impeachment that the House transmitted last year to the Senate as void ab initio. Early this year, the Supreme Court unanimously denied with finality the House of Representatives' motion for reconsideration of that decision, with a reminder that while impeachment is a powerful democratic process to call out corruption and grave abuse, impeachment can be abused, and that impeachment should never be abused to maintain the hegemonic dominance of greed by shaming those who occupy high government positions into preventing them from doing what they were sworn to do. But perhaps the most enduring reminder of the Supreme Court that we must not forget in the entire course of this trial is that, in the words of the court, the rule of law that does justice is our lodestar, and that justice includes accountability. Justice includes fairness. Without fairness, there is abuse. This fairness is what our democracy is all about. It is in light of these reminders that we draw attention to certain fundamental legal principles that we think we must not forget throughout this trial. Mga batayang prinsipyo na dapat nating tandaan sa buong panahon ng paglilitis na ito, anuman ang ating kulay o politika. If we are to be true and honest to our proclaimed values, such as the pursuit of accountability, justice, and integrity in our system of government, then we must remain possessed of an unyielding resolve to ensure that the trial and judgment in this case are done in accordance with the command of the Constitution, the majesty of the law, and the discipline required by the rules. Otherwise, those who stand in sanctimonious judgment of the Vice President will send a clear message that the law can be bent when it suits the convenience of the powerful, and that justice can be sacrificed at the altar of partisan interests.
mahalagang tandaan ang mahigpit na paalala ng ating Korte Suprema. Impeachment is not a purely political proceeding. It is primarily a legal, political, and constitutional mechanism. Ibig sabihin, kailangang naayon sa batas at konstitusyon ang anumang proseso nito. According to the Constitution, it is the Senate that shall have the sole power to try and decide all cases of impeachment. This power is not shared. The Constitution gives no other body, department, tribunal, agency, or a mere committee of any of these institutions the power to try an impeachment case. The House merely initiates, the Senate tries. Yet, we have seen the Committee on Justice conduct what its chairperson, the lead prosecutor in this case, described as a mini trial, which, as we all had witnessed, became a vast fishing expedition of alleged evidence that were not even part of the impeachment complaints under its consideration and which the respondent accused was made to answer. In that mini trial, we saw how the purported pieces of evidence were curated to construct a narrative against the Vice President even before this case reaches trial. The articles of impeachment presented before this court as an exercise of the House's power to initiate impeachment cases are therefore, in sober truth, the product of an impermissible intrusion of clear constitutional boundaries. Over the course of the impeachment trial, the prosecution will attempt to convince this court and the court of public opinion that the allegations in the articles of impeachment are supported by materials they obtained during their mini trial and that evidence exists to sustain a judgment of conviction. They will claim that the notices of suspension and disallowance issued by the COA and the COA decision denying the Vice President's appeal of that disallowance support their accusations, with the release of that decision by the COA conveniently timed and coinciding with the committee hearings. They will claim that the certifications of the PSA confirm their allegation that recipients of the confidential funds do not exist, even though they listed one Mary Grace Piatos in their pre-trial brief as among their witnesses, or that the liquidation of the confidential funds in a span of 11 days was allegedly swift as to invite suspicion. The prosecution will assert that the supposed NBI findings of similar signatures across a number of acknowledgement receipts submitted to the COA are supportive of their conclusion that the disbursements of the confidential funds were irregular. What the prosecution avoided informing the public so far are these: that it was the then Secretary of the Department of Budget and Management, Amena Pangandaman, who issued a memorandum for the President through Executive Secretary Lucas Bersamin on October 18, 2022, recommending the approval of the Office of the Vice President's request for confidential funds. That the Office of the President did in fact approve that recommendation of the DBM through a memorandum from the Executive Secretary dated November 28, 2022, and signed by the former Executive Secretary Lucas Bersamin by order of the President. That on December 13, 2022, the DBM issued a special allotment order number SARO-BMB-C-22-001-2004, signed by former Secretary Amena Pangandaman to cover the request of financial assistance, subsidy, and confidential funds of the OVP that, notwithstanding the impending end of the fiscal year, the confidential funds were nonetheless released to the OVP on December 20, 2022 under this documented approval process. That the COA decision is far from being final, that there is a pending motion for reconsideration of that decision, that, assuming arguendo, the COA denies that MR today, or while this trial is ongoing, as could plausibly happen under the circumstances, the respondent accused still has legal remedies available under the law and rules and can file a petition to question the validity of any forthcoming resolution of the COA on the MR under Rule 64, via petition for certiorari under Rule 65 of the Rules of Court, and more importantly, that nothing in the notice of disallowance or COA decision states any findings of supposed misuse of confidential funds as confirmed by Attorney Gloria Camora when she was asked on this point during the committee hearing on April 14, 2026. Across all other articles, the prosecution will lay a landscape of what it deems to be their evidence in support of their speculations and conclusions. We are not strangers to all these accusations, precisely because this was not the first time these narratives were foisted into the minds of the general public. We have heard the same tales and stories of these accusations since 2024, when the House conducted its Quadcom hearings and most recently the mini-trial of its Committee on Justice. But what we must not forget amid all these accusations is the fundamental legal principle that the burden of proof never shifts. The burden of proof never shifts. He who accuses must prove his allegations with evidence that meets not only the degree of proof required, but also meets the evidentiary standards of admissibility, credibility, relevance, materiality, and competence. We therefore should not lose sight of the core principle that the burden of proof is on the prosecution, and unless it discharges that burden, the accused need not even offer evidence on her behalf, and she will be entitled to an acquittal. This is the law then. This is the law now. And the underlying principle for this burden of proof is simple. Under our Constitution, every accused is presumed innocent until proven otherwise. An accused has in her favor the presumption of innocence, which the Bill of Rights guarantees. This also brings to fore the reality that, in the words of the Supreme Court in People versus Pagal, the individual citizen is but a speck of particular molecule vis-a-vis the vast and overwhelming powers of government, and his only guarantee against oppression and tyranny are his fundamental liberties under the Bill of Rights, which shield him in times of need. Sa madaling salita, kinikilala ng ating saligang batas na sa bawat paglilitis, ang isang individual ay nahaharap sa malalim at napakalaking makinarya ng buong Estado. At ang tanging sandigan lamang niya laban sa anumang pang-aabuso ng kapangyarihan ay ang kanyang mga batayang karapatan sa ilalim ng ating konstitusyon. Kaya't mahalagang linawin na sa gitna ng pagtatangkang ikondisyon ang kaisipan ng mamamayang Pilipino at sa gitna ng walang humpay na komentaryo sa mga pampublikong espasyo, wala pang maituturing na anumang ebidensya o alegasyon na napapatunayan ng prosekusyon sa simpleng dahilan na ang bawat ebidensya ay kailangang dumaan muna sa paglilitis at pagsusuri ng korteng may tanging kapangyarihan sa ilalim ng ating saligang batas. Higit sa lahat, ang anumang paglilitis ay kailangang naayon sa itinatakda ng ating batas at konstitusyon at hindi lamang sa kagustuhan ng iilang may hawak ng kapangyarihan. One might ask, why is it important that we must not forget these basic principles? The ruling of the Supreme Court tells us why. The Bill of Rights applies to the entire impeachment process because inasmuch as our court recognizes that impeachment is a political process, it reminds us that it is not a purely political process but a legal and constitutional mechanism. Thus, if we are to uphold the rule of law, serve justice, and invoke the accountability mechanism, then this court and we as a people must guarantee that all efforts to hold our leaders accountable must be done right. This we must not forget. I thank the court and the public for the privilege of your time. May God bless our country.
Opening statement of the Counsel for Respondent. It's duly noted and entered into the records.
So natapos na ang
Before- yeah,
opening
oo nga.
statements, no? Oo, at least na nag-proceed na yung trial. Akala ko kanina
Salamat
stuck
naman.
na tayo sa issue ng presiding officer. But before we go on a break, let's go to maybe some thoughts of Attorney Mel Santa Maria.
Well, alam niyo naman ang opening statement, hindi evidence yan. Sinabi nga ng Korte Suprema na ang isang impeachment proceeding ay constitutional, legal, at political. Ito ang political side. Kasi dapat sa opening statement, you define that you are the party who is on that high moral ground. Kaya you do not have to talk about the specifics of evidence. You do not have to talk about the detail of what you will do. But you have to espouse values, the constitutional principles, at itutugma mo sa ilang mga articles of impeachment. Kaya hindi natin narinig si Luistro na dinidetalye niya yung articles, no? Sapagkat yun ang punto ng isang opening statement. Maakit mo ang husgado para in the future hindi sila mag-bog down sa mga technical intricacies, no? Yung titignan nila yung overall tema ng kasong ito. Yung sa sa prosecution, para siya nag-lecture. No, para siyang teacher na nagle-lecture siya on the Bill of Rights, on the presumption of evidence. Ang problema kasi
defense, you mean defense?
Defense pala. Ang defense pala, para siyang nagle-lecture, no? Bill of Rights, defense, tapos andain yung mga tanong tungkol sa mga technicality na malamang matutune out ka. Hindi ko na siya masundan. So, iyon yung diferensya ng dalawa.
Yeah, I noticed the style is really different. Kasi kay Congresswoman Luistro, she's really emphasizing yung narrative na this affects yung pera ninyo bilang taong bayan, yung tiwala ninyo. But then with Attorney Sheila Sison, it's really on the rules that she put emphasis on. That's my take lang.
Yes. But is that the point of a opening statement? Sa opening statement, dapat makuha mo yung tao at makuha mo rin yung ibang mga judges, no? So that therefore, hindi ka na magdi-deal masyado sa detalye ng ebidensya, kundi you let the judges know, we are on the higher plane here. At saka, pinapakita nila, we are the good side. So, yun lang. Pero yung kabila, ang nakita ko lang, para tayong nila-lecturean sa isang classroom.
What about yung point niya at Dean Mel and Attorney Edwin na parang for the defense, parang meron siyang pahapyaw na if yung sa prosecution, they should also exercise or have the same standards on conduct and also, ano pa ba yung standards na minention?
May pahapyaw na banat sa mga sa mga prosecution.
Yes,
Ang problema dito, nung nagpresenta ng ebidensya kasi sa House Committee on Justice, 100% na ebidensya lang na nakita natin, prosecution. 0% sa defense.
Because they were questioning the validity of the proceedings, diba? They went to court. At first, they even tried to get a TRO.
Oh, but that is water under the bridge. Kasi nahandito na sila sa Senate, proceedings. So ang ibig sabihin ko, teka muna, may kaiba kayo na umangal. Kasi nahandito kayo, as a matter of fact, yung House Committee on Justice, dress rehearsal yon. Kaya lang hindi nila ginamit. So ito, okay. Di ang ibig sabihin, titignan na namin ang ipepresenta nyo. Di ba? Parang gano'n ang mangyayari.
My point was, when we say na may pahapyaw, ang impression sa akin is parang merong patama na, ano ba yung analogy dito? You can't come to court if you have unclean hands just because siguro parang meron silang meron ding corruption on the side of public officials. Yun ang take ko, di ba?
Must come to court with clean hands. Kasi tinutukoy niya mga congressman, di ba, marami rin sa inyo, may flood control na issue. Tapos binabanatan nyo ito. Ito yung argumento dati na ang ninakaw lang, kinuha lang ang issue lang kay VP Sara, hundreds of millions lang. Ang congressman, billion ng yun ang ginagamit na comparison niya.
Pinatatamaan niya rin yung mga senators.
Correct.
Kasi yung mga husgado, sa inyo ba may malinis kayo? So parang lahat pinapatanamaan niya na, except si VP Sara. So baka mag-backfire yun. Yun lang ang aking napupuna dito. So tignan natin kung ano ang niya. backfire niyan o talaga nakatulong ba yan sa pagsiset ng tone sa defense at saka sa...
Maganda yung analogy ni Jinky Luistro. Nagtagalog siya nung sinasabi mo na naglulustig ko nagnakol ng 5,000 pesos, kinakasuhan na. It's very masa. Kaya nagtagalog siya ron eh. Yung mga analogy niya, kinokompara kay Vice President, tinagalog niya, for the purpose of educating the masa, ito ang nasa issue ngayon. There are different set of laws, rules. Pag mahirap ka, sa presinto ka magpaliwanag. Pero pag mataas kang tao, iba ang, parang yan ang tinutukoy yata ni VP, ni
Kasi
Jinky.
ang proceeding ng impeachment, constitutional, legal, at political. Nasa political tayo. You must have flair in the delivery. You must have grassroots examples. You must set the tone that you are on a higher plane. We are the morally right here. So yun ang tema niya. Hindi
And
siya
do you
nagre-lecture.
think that the prosecution here has that morally high plane? Because I remember former Congressman Neil Tupas in one of our interviews here in Bilyonaryo News Channel, yan ang isang sinabi niya rin that it's different this time in this impeachment compared to the impeachment of Chief Justice Corona. Kasi sabi niya, parang walang moral ascendancy ngayon yung prosecution because of this whole corruption that was exposed during the flood control controversy. Compared doon sa time ng impeachment ni Corona na we have a president that time na tuwid na daan ng kanyang platform and wala siyang corruption issues na nag-hound sa kanya.
Baka isa pa a reason why yung mga kinuha sa prosecution, walang issue yung mga prosecution team on flood control. Parang yun ang ginawa nilang
baka,
None of the prosecution members, if my memory serves me right, are not involved in flood control scam. That's why, in that respect, itong mga prosecutors, nakaiwas sila. Pero yung House as a body, may tama. The Senate as a body, may tama.
So yun ang nagiging red herring. Sapagkat dapat panatiliin natin ang focus. Ang focus dito, iisang tao lang. VP Sara Duterte at ang mga nilatag na ebidensya. Yung mga ebidensya ba credible? Ito ba ay clear and convincing evidence? Ika nga ni Senator Presiding Officer. Yan ang titignan natin. Kung dapat hindi malihis ang tingin ng tao doon sa focus ng kaso.
Pero Mel, ang tingin mo sa performance naman nung dalawang
Yan ang gusto ko rin tanungin eh. Non-legal question,
Non-legal
but based
question.
on your assessment, how did they fare?
Ako nakita ko yung pagmumukha ni Congressman Luistro, malambot, concerned, at saka yung demeanor niya, at talagang pinapakita niya yung passion niya sa ginawa nila. Pangalawa, yun na nga ang sinasabi ko, niligay niya sa mataas na moral plane ang kanilang objective. Pinakita niya kung sino ang tama dito. So, good yun. Very, very excellent yun. Excellent pala yun. Hindi pwedeng very excellent yun. Ngayon naman dun sa kabila, si attorney, maganda rin yung sinabi niya. Talagang structured talaga. Pero para siya nagle-lecture. There is a point in time na tune out ka na. Kasi hindi mo na siya maintindihan. At hindi
too
mo
technical.
Hindi mo na siya masusundan. So, yun ang problema doon. So at this point, para sa akin, medyo lamang si Luistro dito. Kasi inexploit niya yung political aspect or political nuance ng isang opening statement.
Thank you so much, Attorney Mel Santamaria, for joining us today. We'll pause for a quick break. Stay tuned to BNC's VP Sara on Trial, a BNC impeachment coverage.
Welcome to the bigger, better, and bolder Bilyonaryo Quiz Bee Season 2. The road to becoming the Bilyonaryo News Channel's next Quiz Bee Millionario is filled with challenges that test both wit and will. And with a total prize pool of over 2 million pesos also paving the way, the nerve-wracking journey is well worth it. We are proud to be joined by our partners.
Rise above the rest and become the next Quiz Bee Millionario.
And I'll be
Your next Quiz Bee Millionario.
Bilyonaryo Quiz Bee Season 2, College Edition on the Bilyonaryo News Channel.
Mga kwentong humuhubog sa North America. Mga boses ng Filipino-American community. Mga balitang nag-uugnay sa ating lahat. Ako po si Henny Espinosa at ito ang Agenda North America.
Powerful stories, fresh perspectives, and deeper conversations. We continue to learn the winning strategies and champion mindset of winners, movers, and shakers. I'm Charles Tew. Catch the all-new season of Beyond the Game. Watch us every Wednesdays, 8 p.m. only on Bilyonaryo News Channel.
A political reckoning, a nation on watch as the impeachment trial of Vice President Sara Duterte unfolds. Every testimony, every motion, and every decision carries consequences beyond the halls of power. And your Bilyonaryo News Channel will be there with comprehensive expert analysis and real-time updates. VP Sara on trial, a BNC impeachment coverage. Get today's memo.
Isang taon na pala yun, pero naghihintay pa rin kami ng makukulong pa. 85 pesos na daily minimum wage hike. Kakainin lang ito ng VAT sa nangyaring school shooting sa Tacloban. How do we make sure that this doesn't happen again? Do you agree? We are already in the upper middle income status.
Yung status na yan ay nilikala ng World Bank.
Memo with Corina Sanchez Rojas. Monday to Friday, 7:30 a.m. on BNC. A brave new partnership is here, taking another bold step to bring real stories and trusted journalism closer to more Filipinos. Going beyond limits, Bilyonaryo News Channel is now on CLTV 36, expanding reach across Central Luzon. Because the stories that matter should be everywhere. BNC, the Bilyonaryo News Channel.
Sa bawat issue may anggulo at ang balita ay agenda.
Panahon na nga ba para limitahan ang oras ng mga bata sa social media? Kailangan na rin ba ng total ban sa video games?
Lalo na po itong si CICL alias na ay heavily influenced po ng online content.
Bumuhos ang paghihinagpi sa libing ng Ateneo student athlete na si Rene Baterbonia.
The Philippines is moving fast, and so are we. Bilyonaryo News Channel is now live on GSAT Channel 40, reaching a broader audience across Visayas and Mindanao, with brave stories and bold insights that shape business, economy, and the country. From Metro Manila and beyond, Bilyonaryo News Channel.
Welcome back. You're still watching BNC special coverage of Vice President Sara Duterte's impeachment trial.
Joining us now via Zoom is former House prosecutor during the Corona impeachment trial, and he was also the head for the prosecution at that time, former Congressman Neil Tupas Jr. Kong Neil, there. Good afternoon.
Yes, good afternoon, Attorney Karen. Good afternoon, Attorney Edwin.
Ano, Junjun, kamusta ang buhay na ano? You've seen, how do you compare the trial now and panahon mo?
Well, siguro, judging sa first day, Attorney Edwin, halos pareho lang, no? Except na mas maraming, may mga debate nung time ni Corona with respect doon sa motion to dismiss. Pero I think, magkaiba yung circumstances. With respect to magkaibang-kaiba. Si Corona was the Chief Justice of the Supreme Court. Ito ngayon, the Vice President was declared their intention to run for President. So, mas political ito. Ang kay Corona impeachment was shortcut. Bigla kami nga, we had 1 to 2 weeks to prepare before trial. Ito naman, 2 years to prepare yung House prosecution dahil nag-start ito noong 2025 pa, last year pa.
And what is your take on the opening statements? Para sa'yo, personal opinion, kanino yung mas naging effective? Is it Congresswoman Luistro versus Attorney Sison?
I don't think it will really make a difference, no? Yung opening statement. I think what will make a difference will be from the start of the trial na until its conclusion. And ang opening statement kasi dinalatag mo lang naman eh. Of course, the prosecution nilatag lang ang 4 articles of impeachment. Ang defense naman ang depensa nila. And they want to destroy those allegations. But what will matter really here is paano na yung trial na ito? Will it really take 92 days, Attorney Edwin? 44 days lang Corona, it took us 6 months. Well, ano mangyayari dito? Pag 8 months, sino bang matatalo? I think the more this case will drag on, it will be to the disadvantage of the prosecution. Because there's such thing as an impeachment fatigue sa tao eh. And next year will be election time. So what will really matter will be from tomorrow siguro until the conclusion. Tatapusin ba ng prosecution yung 4 articles of impeachment na 6 to 2 days of presentation of evidence? Or tulad namin, na inuna lang namin yung strongest. And you know, after a couple of articles, we rested their case. And importante dito, manalo ka. Importante you get the 16 votes.
So para sa'yo, Attorney Neil, kailangan kung kakayanin, iklian ng prosecution yung trial days?
Definitely. Definitely, hindi pwedeng sobrang tagal. Because naantala na itong impeachment trial na ito by 2 years na, di ba? 2025, 2026. 2027, will be a filing of the COC na. And, you know, this is quasi-judicial, quasi-political. Kaya hindi pwede talagang humaba ito. Dahil pag once na nawala na yung interest of the people, it won't be to the disadvantage of the prosecution.
So, having said that, Junjun, ano ang advice mo sa ating mga prosecutors ngayon? Dahil may experience ka bilang isang prosecutor dati.
Not only a prosecutor, siya head prosecution dati ng team nila.
Ano mga things to watch out? Things to ano
Well, number one siguro. Number one, may nag-sequence na sila eh.
Okay.
They already ang Article 1, 2, 3, 4. And kami, we didn't follow it, yung sequence. We asked for leave of the impeachment court na unahin yung strongest articles. So, yun siguro ang pinaka-importante because Attorney Edwin, Attorney Karen, you only need 1 article to impeach. You don't need a lot of articles. So, doon siguro yan. Tapos, I observed na mayroong mga common witnesses sa pre-trial conference. And remember, during the time of Corona, doon nagkamali yung defense, no? Yung hostile witnesses. Kasi pag present mo yung hostile witnesses, you should be sure kung ano yung sabihin niya na hindi against you yun. So, doon nangyari, di ba? Yung hostile witnesses na present ng defense at the time, doon na booking eh. Let's for example, gusto mo Conchita Morales, na booking na mayroong pala na foreign accounts. So yung marami silang mga present kanila the impeached public officer. So titingnan din siguro ito ng defense sa huli kung kailangan nila i-present
So bali, ibig sabihin, what you're saying, Attorney Neil, kailangan i-weigh ng defense if they should present Vice President Sara to avoid the same pitfall na nangyari nung Corona impeachment?
Because I think you will agree with me, Attorney Karen and Attorney Edwin, na mas madali yung trabaho talaga ng defense, generally. Diba? Generally, it's easier to build a house. No, generally, it's more difficult to build a house, like a prosecution, step by step, than destroying a house. So mas, let's say, yung building of ng prosecution, malalaman nila yan eh. Kung kailan na, kailan yung peak. And I think sa peak na yun, pwede na yung rest ng case.
Jun, may last question ako sa'yo.
Magtagal.
Jun, may last question ako sa'yo. Di ba you had several articles of impeachment? Kailan yung nag-decide na, hindi, huwag na natin present ng iba? Let's rest our case. When did you decide that?
Ano lang yan, ha? Talagang mga 2 days before lang yun. Ha?
But what was the basis for saying, let's rest our case?
Which articles of impeachment daw?
Again, are you asking me regarding corona?
When did you realize na parang, nakuha na natin ang taong bayan, let's rest our case? May ganun ba kayong decision?
Yes. Kasi Attorney Edwin at Attorney Karen, I think the most important here with the public opinion. This is a quasi-political, quasi-judicial. So, once you have a strong case, feeling mo strong ng case, and feeling mo the public opinion is with you na, I think that's the peak. And you have to rest your case. Hindi pwedeng hindi dapat sa peak ka at the time when you rest your case.
So to reiterate Attorney Edwin's question, nung time ninyo, at what point did you feel, okay, this is the peak and therefore we should rest our case and not present the other articles of impeachment?
Ngayon, 4 articles of impeachment. At the time ni Corona, 8 articles of impeachment. Yun. So, once na-present na feeling namin is the SAL-ENON. Kasi lumabas na yung foreign accounts, lumabas yung mga accounts na local, domestic. So, lahat yun. Tapos na feeling namin, the public opinion is already on our side. And ang pakiramdam namin nun, pag dinag-on pa natin ito, mawawala yung momentum. And that was hindi yun, hindi yun, parang mabilisan na decision yun. And in fact, yung media nga nagulat rin, di ba? Even the impeachment court at the time, nagulat sila when we decided to rest our case.
Maraming salamat po, former House Prosecutor during the Corona impeachment trial and former Congressman Neil Tupas Jr.
Thank you, Jun.
Thank you so much. Salamat.
Let's go back to the impeachment trial, which is now ongoing.
Today. Second, if Your Honor, please, integrity, hindi po pwedeng biyakin po yan na kesa dati ay hindi po ganon at ngayon may integridad. It's very clear that integrity is a continuing requirement of fitness for office. Thank you, Your Honor.
Duly noted and entered into the records.
May I respond? Just very briefly, Your Honor.
Counsel correspondent.
Much time of the impeachment court.
As a rejoinder to the statements and manifestation of Representative Jogna, briefly.
Thank you, Your Honor.
You may proceed.
I think the good counsel has already stated precisely the reason for our position. We maintain our belief that the Duterte versus HOR ruling precludes any of these trawling incursion, again, on private records of so many individuals and so many entities when nothing in the articles of impeachment point to any specific allegations as to the relevancy of all these documents, Your Honor. But nonetheless, we will include all our position and as well as our objections on the request made today with respect to these documents. And what it would seem to the defense would be another 2.0 version of a fishing expedition. May I also, Your Honor, just to clarify also the period given to us to comment on the request for subpoena, may we ask that the 5-day period run from our receipt of the copies of the documents, Your Honor.
We will make sure that the counsel for respondent will get that today.
Thank you, Your Honor.
The comments of both counsels of the parties are duly noted and entered into the records. Chair would like to apologize to Senator Cayetano, who has been waiting for quite some time. Thank you for your patience and indulgence. Senator Cayetano is recognized. What is your pleasure,
Presiding Senator Judge. Since we already stated as a court that we will take literally Section 3, subparagraph 6 of Article 11 of the 1987 Constitution, that no person shall be convicted without the concurrence of 2/3 of all members of the Senate. may I ask the members of this court through the presiding justice to consider, not today, I have a proposal, but not today, but to consider communication with the Sandigan Bayan for the attendance of Senator Dante Marcoleta and Senator Jinggoy Estrada, considering that the presiding officer may correct me if I'm wrong, but if we get to Section 21, as discussed a while ago by the defense, the prosecution and defense, and we do not know what will happen. Their case may be dismissed. They can be out on bail. So we want them to be able to participate and observe the witnesses as senator judges here. I do know that Senator Jinggoy is under suspension, but there's an argument to be made that the impeachment court is sui generis. Persons under their custody be delivered to the Senate under, or the House of Representatives under certain conditions. So I'd like to formally ask, Mr. President, that this court consider that. I will submit whether you'd rather have a caucus or a in-camera discussion, or if you want us all to submit our legal opinion. I wouldn't also mind the prosecution and defense weighing in. But considering that if they do not attend and they are here, sorry, Mr. President, considering that if they do not attend at all and cannot vote, their vote will be equal to a acquittal. And as we said from the start, we want a fair and we want justice, we want a fair impeachment trial. Sinabi ng prosecution na sana tignan yung ebidensya, pakinggan mga witnesses. So kahit gawin to ni Senator Marcoleta at kahit gawin to ni Senator Jinggoy, and of course this is my personal opinion that may politika sa pagpapakulong sa kanila. That's my personal view. Allowing them to attend here might add to the integrity of the proceeding and actually make things easier when the time comes to render a verdict. So may I submit that to the court and to our colleagues for discussion at the proper time, Mr. President.
The chair notes the comments and requests of Senator Judge Cayetano and will consult the senator judges regarding this matter and shall coordinate with his office with respect to his requests pertaining to Senators Jinggoy Estrada and Senator Marcoleta, including whether or not we will enlist the comment on and position of the parties to this case. So ordered. Senator Tulfo, what is the pleasure of Senator Judge Tulfo? Rafi?
Mr. Presiding Officer, as far as I'm concerned, I would allow siguro mag-monitor yung mga si Senator Jinggoy, Senator Marcoleta. They will be allowed na kahit man lang yung sa TV monitor. Para sa akin, I do agree with what Senator Alan Peter Cayetano was suggesting. Thank you, Mr. Presiding Officer.
The point of Senator Judge Rafi Tulfo is well taken by the chair. Any others? If there are none, Presiding Officer would now like to deal with an administrative matter before we adjourn for this afternoon. On the matter of providing public access to case records, yes, Senator Judge Marcos, what is your pleasure, ma'am?
Yes, Presiding Officer, may I request an update? As I recall, during the pretrial conference, there was disagreement on how to go about the markings on the various documents, and among the thousands of pages that we have received in evidence for the trial, it apparently was resolved that the counsels would place their initials on the evidence. Is that correct? Is that still what stands today? And each party would take their respective evidence or files and present the same during the trial to guarantee that the same evidence would be presented. Is that correct?
That is correct, with the exception of some, I think, documents that where the original was not presented, which is being corrected, I think, by the parties as we speak.
Are we in fact in receipt as judges of all these thousands of pages? Dahil ako, simple lang hinahanap ko yung affidavit of investigation, yung dalawang NBI na unang testigo na sana haharap ngayon, nakita ko sa libu-libong pahina na sinubmit, mali-mali ang pagka-annex ng AOI, hindi ko talaga mahanap. Tapos, ang sabi doon, Annex G. Pero nung kinalkal ko yung Annex G, hindi naman affidavit yun, kundi disbursement voucher or something like that. Kaya hindi ko alam kung nag-provide ba talaga ang clerk ng Senate ng records as marked during pre-trial at kung pinal na talaga ito at pag-aaralan natin.
At this point in time, Your Honor, documentary evidence as of yet has not been formally offered and therefore has not been turned over to the court. Neither has it as of yet been identified by a witness to authenticate the same and to be allowed admission into the records of this court. That time will come once the prosecution presents their witness and identifies the piece of evidence. That will be the proper time, perhaps, that the good Senator Judge can ask for a copy because the lady might want to ask questions of the witness should that time come for the witness to testify as to the document marked previously erroneously or rightfully by either party.
Yes, precisely. Thank you very much, Presiding Officer. We wish to prepare for the three first witnesses and we're unable to access any of their affidavits or other documents. Thank you.
Duly noted and entered the records. What is the pleasure of Senator Judge Padilla?
Ginoong tagapamahalang hukom, gusto ko lamang pong sundan yung sinabi ni Senator Judge Alan Peter Cayetano at magpasalamat po kay Senator Judge Raffy Tulfo. Gusto ko lamang pong linawin na ang hinihingi po namin kung hindi man makapag-participate dahil sinasabi nga po ay ipinagbabawal silang makapag-participate at bumoto si Senator Jinggoy Estrada at Senator Judge Marcoleta. Ang hinihingi po namin ay makapunta po sila dito bilang observer. Hindi lang po basta monitor. Yun lamang po. Maraming salamat.
Noted, at the proper time we shall discuss this matter and settle it as a court or in caucus. There being no other Senator Judge who wishes to make a manifestation, comment, and or motion, Chair would now like to dispose of an administrative matter. Consistent with Article 2, Section 28 of the Constitution on the policy of public disclosure in matters involving public interest and to give life to the directive under the rules to open the impeachment proceedings to the public, the court hereby directs the clerk of court to create the necessary internet web pages to allow the electronic records of impeachment to be made accessible to the public through the Senate website, whereby all pleadings, memoranda, motions filed by the party shall be uploaded, including the journal of the proceedings after it shall have been approved by the impeachment court. Yun lang po siguro yung madedelay ng konti dahil kailangan aprubahan muna ng impeachment court yung journal bago po namin ma-upload sa website. Yes, what is the pleasure of Senator Judge Bam Aquino?
Yes, Mr. President, on this note, firstly, we'd like to second and congratulate this move of the impeachment court to make all of the evidence available to the public. May we know in how many days will the clerk of court make this evidence available to the public, Mr. President?
They've started, but they have not completed it yet. As Senator Judge Marcos said, the documents are voluminous. I think it covers until 9Q, if I'm not mistaken, initially, when it was marked. About more than 10,000 documents.
Mr. President, of course, in the same way, if this is made available to the public 6 months from now or 1 year from now, that defeats the purpose of having this made public.
No, that will not happen.
Yes, may we get a commitment from the clerk of court as to the delay by which presented evidence is made public, Mr. President?
No. Let me clarify. Your Honor, I believe the articles of impeachment as well as its annexes have been uploaded. The answer as well as its annexes have been uploaded. And most of the exhibits that were marked, not all, are annexes of either the impeachment complaint and or the answer. Can the chair give you an update before the week is over as to a realistic timetable to upload in real time already? Again, except for the journal, which we need to approve. So we cannot upload the Wednesday transcript or journal until we meet again on Monday and approve the journal of Wednesday. So that would be the only delay, if at all, in uploading it. That should be the only delay.
So if I take it correctly, Mr. President, the clerk of court will endeavor to upload all of the presented evidence in real time at the soonest possible time, except for the journal, which needs approval of the body.
That is correct, Your Honor.
Thank you, Mr. President.
Senator Judge Cayetano Allen.
Presiding Senator Judge, just a clarification. No? So no problem with complete transparency with any public records. But when we talk about evidence, precisely that's why we want a fair trial, due process. There's a process wherein the prosecution shall present the evidence, then they will offer it. And then if there's a question as to the relevance or if it is prohibited. For example, if a evidence presented is a fruit of the poisonous tree, will we upload that? We haven't decided yet here whether we will accept it as evidence or not. So let me tell you first which ones personally I don't have a problem with. Don't have a problem with the public records in general being completely transparent. I have no problem with senator judges given time to review everything, and I assume we're all trained to consider only the evidence that is later on admitted, offered and admitted. So my problem is that, for example, no, if someone offers now, between now and the trial, wiretapped recordings, do we upload that when we have not made a ruling yet on that? So I just want to be clarified on that.
The chair will clarify. As the chair said earlier, only the pleadings, motions, and memoranda filed by the parties, and insofar as the exhibits marked are concerned, only those attached as annexes to either the articles of impeachment and or the answer to the impeachment complaint. Insofar as documentary evidence is concerned, it will only be admitted, and if at all admitted by the court, and published once formal offer has been made. Until such time, we will not publish any documentary evidence even after being identified by a witness, because it is the formal offer that will determine its admission by the court after the
Same
party
thing,
rests.
just to clarify, same with if we do issue a subpoena, duces tecum.
The subject matter of the subpoena will not be published, but the motion for the issuance of a subpoena
Thank you.
will.
Thank you for that clarification.
Thank you, Your Honor. Senator Judge Erwin Tulfo is recognized. What is your pleasure, sir?
Thank you, Mr. President. Thank you, Mr. Presiding Officer. Just want to be clarified. I need a clarification, Mr. Presiding Officer, with regards to this Anti-Money Laundering Council documents or pieces of evidence that will be submitted here. Will it be okay if we tackle this in public, or shall we tackle evidence from the AmLoc during an executive session? I believe these is under the bank secrecy law, or we can tackle it because this is an impeachment court, Mr. Presiding Officer.
What we will debate upon, if at all, on the scheduled date to be set by the chair is a debate on whether or not to issue the subpoena duces tecum ad testificandum in relation to AMLC records, not the actual records yet. Once it is granted by the court and is issued, it will have to be presented by the parties. We cannot tackle and discuss it in executive session because anything and everything discussed in executive session cannot be revealed into the public and used by this court. Secondly, it can only be, if at all, revealed by a unanimous vote or consent by all the senator judges, which effectively hog-ties that piece of evidence if we discuss and talk about it only in executive session. Whether or not it is to be made public, whether or not it can be legally obtained, will be decided by this court after hearing the oral arguments of the parties.
Thank you for that clarification, Mr. Presiding Officer.
What is the pleasure of Senator Judge Villanueva?
Yes, Mr. President. Considering that we have been tackling and asking of pieces of evidence, I think there's a lot of questions with regard to the mahiwagang BIR box, Mr. President. Yung clarification lang po, where is it now and when are we going to transfer it to the Bureau of Internal Revenue?
It is with the Clerk of Court in the Office of the Secretary General as instructed by the Chair. It should be sent back to the BIR by tomorrow morning in the condition that it was received, meaning sealed.
The same. Thank you, Mr. President.
Any other manifestations or motions on the part of the senator judges? Senator Judge Ontiveros is recognized. What is your pleasure, ma'am?
Salamat po, Mr. Presiding Officer. Just to make a brief statement in support of the ruling recently proclaimed by the Presiding Officer on executive sessions. Thank you, if I may,
Noted.
Mr. Presiding
And entered into the
Officer.
records.
And just to add a little bit of that,
Lady, may
Mr.
proceed.
Presiding Officer, thank you. The executive session is only for Congress acting in its usual legislative functions, and impeachment trials do not contemplate executive session. So I join with the Presiding Officer in the call that he made, which I believe is the default also of this impeachment trial court for transparency as a general rule and as a default. Salamat po, Mr. Presiding Officer.
Thank you, Senator Judge Ontiveros. Before the court adjourns, Chair directs the Clerk of Court to kindly make sure that the subpoena for the two NBI agents will be issued this afternoon and duly received, and entrusts it to the Council for Prosecutors to make sure of the attendance of their two witnesses tomorrow. Likewise, the Chair reminds the Clerk of Court to furnish, right after we adjourn, Council for Respondents with a copy of the requests for the issuance of subpoena thus far submitted and filed with the Office of the Clerk of Court. So ordered. There being no other business to discuss, the trial is hereby adjourned until 2 p.m. of Tuesday, tomorrow, July 7, 2026.
Okay, that concludes day one of the impeachment trial against Vice President Sara Duterte. Was it everything that you expected, Attorney Edwin?
Yeah, more than that. We
More
thought
than
it was
that.
going to be just a usual, but it was fireworks already started even on day one. Pa
Oo,
lang.
kasi yung presiding officer issue. No, but actually, for me, I was also caught by surprise because I thought settled na yung issue na presiding officer would have been the Senate President Win
Right.
Gatchalian. So marami pa ring surprises talaga.
Plus also yung sinabi ni Alan na asking the two senators who are incarcerated to be allowed. Kasi
Yes.
an
Or
absent...
tsaka si Senator Robin Padilla also raised that,
Yes.
no?
Ang sabi ni Alan, which I found strange, is an absent vote is equivalent to an acquittal, which is not...
Oo
I
nga,
don't think
parang
that's
hindi
correct.
tama yun.
I don't
At the
think that's
most,
correct.
abstention.
Abstention
I
lang
think.
siya,
Yeah,
so
oo.
it doesn't add up to an acquittal.
Yeah, and it was going to be, I think in the coming days, it will be exciting to see whether the courts that are hearing the cases of Senators Marcoleta and Jinggoy Estrada will allow
Plus
the
also,
attendance.
the burden is more on the 16 votes rather than the acquittal, di ba? So,
that's
mas
true.
mahirap i-achieve yung 16 rather than the
Yeah, because the burden is on the prosecution.
burden is on the prosecution.
Okay, before we wrap up today's special coverage, let's get the side of the prosecution. Isaiah Mirafuentes is on the line. Go ahead, Isaiah. Isaiah? mukhang nagkakaproblema pa tayo sa signal right now. Try natin ulit. Isaiah, are you there?
Baka naghahabol ng mga ano.
Oo. Ayan.
Ayun na.
Isaiah. Okay, sige. Babalikan na lang natin sa Isaiah sa Senate. Siguro makakapag-interview siya ng mga senator judges.
Ano dyan na yata?
Okay, let's try again. Okay, so hindi tayo makakonect with Isaiah. So, that's the first day of Vice President Sara Duterte's impeachment trial. Stay tuned to BNC for this continuing coverage. I'm Attorney Karen Jimeno.
And I'm Attorney Edwin Lacierda. The full story on today's impeachment trial in Agenda at 6 p.m. And thank you for watching.